Morning, Becky.
I do.
Maybe it's just me. There we go. I hit the wrong button. Representative Babbage, if you are within the sound of my voice, would you join us in 228, please, for purposes of establishing our quorum? Thank you. For the audience, we're waiting for our seventh member to arrive to establish a quorum, and then we'll be off and running. Good morning. Welcome to what should be the last meeting of the Judiciary Committee. During this period anyway. I'm Mike Carpenter, the Senate Chair. Before we get started, we are in the State House in room 228. We're going to need to establish a quorum. I'd have the members introduce themselves, beginning with the good representative from Kennebunk.
Good morning, Mr. Chairman and fellow members of this esteemed committee. My name is Christopher Babbage. I represent House District 8, which is most of the town of Kennebunk.
Good morning. I am Senator Shenna Bellows. I represent Senate District 14, which includes 11 towns in southern Kennebec County.
Good morning, and thank you for being here today. My name is Tom Harnett. I represent House District 83, which is the town of Farmingdale and the city of Gardner.
Good morning, Representative Jeffrey Evangelos, House District 91. I reside in Friendship, and nice to see everybody again.
Good morning again. I'm Mike Carpenter, Senate Chair, Senate District 2, Prescott to Patton.
Good morning. My name is Donna Bailey. I represent House District 14, which is part of the gorgeous city of Saco, and I'm the House Chair.
Good morning and welcome. My name is Rachel Talbot Ross. I represent House District 40, which is part of Portland.
Good morning. My name is John DeVoe. I represent House District 149, Caribou, New Sweden, and Westmoreland.
David, are you Representative Hagan? There we are.
Hello, I'm Dave Hagan. I represent House District 101, Hamden and Newburgh. Nice to see all of you.
Thank you. Representative Reckitt.
Hi, this is Representative Reckitt from South Portland. I represent District 31. And I'm unfortunately sitting outside the doctor's office, which I forgot I couldn't go into. So I'm in the car waiting.
Nice to see you.
Nice to see you.
Other member, I don't think there are any other committee members. All right. So
Barbara Cardone, House 127, Bangor.
Barbara, I apologize.
It's okay.
My apologies. When we get back to the bills involving the tribes, I'll go through another series of introductions with regard to the tribal members and chiefs who are joining us. But for right now, we're going to deal with a couple of other matters. The first thing I want to deal with is LD 1967. You may remember this was the bill Representative Toole introduced to establish a new prosecutorial district in Down East Maine. It's my understanding that one member of the committee, when they voted incorrectly. So I would look for somebody, it was a unanimous committee vote here in the body. I would look for somebody to move to reconsider. Do you recognize Senator Bellows?
So moved.
Move to reconsider by Representative Bellows, seconded by Representative Bailey. Discussion? All in favor? Thank you. All opposed? All right. The motion reconsidered does prevail. Pending motion before the body would be ought to pass as amended, before the committee would be ought to pass as amended. Any discussion for Senator Bellows?
So moved.
Oh, okay. Seconded by, moved by Senator Bellows, seconded by Representative Bailey. Any discussion on the motion ought to pass as amended? If not, I would request members have to come back again. I'm sorry, folks. Representative Babbage, you're going to have to make your way back down here. I should have asked you to hold on. Yep. So Representative Babbage is on his way here, and we'll vote just as soon as he gets here. The way it works, for those of you who might be new, we can't begin the meeting. We can't have a vote unless there's a quorum present in the room. So therefore, we have several members who participate in other rooms in the building, and then they have to come to room 228 in order to vote in person. Representative Babbage has joined us, and the secretary, which, by the way, I should have mentioned, we're staffed by the incomparable Peggy Reinsch as our analyst and Susan Panett as our committee clerk. So I'd ask Ms. Panett, please, to call the roll.
Representative Cardone. Representative Cardone is absent. Representative Harnett.
Yes.
Representative Harnett votes yes. Representative Evangelos.
Yes.
Representative Evangelos votes yes. Representative Curtis. Representative Curtis is absent. Representative Reckitt. Representative Reckitt is absent. Senator Bellows.
Yes.
Senator Bellows votes yes. Senator Carpenter.
Yes.
Senator Carpenter votes yes. Representative Bailey.
Yes.
Representative Bailey votes yes. Representative Babbage.
Yes.
Representative Babbage votes yes. Representative Talbot Ross.
Yes.
Representative Talbot Ross votes yes. Representative DeVoe. Representative DeVoe is absent. Senator Keim. Senator Keim is absent. Representative Hagan. Representative Hagan is absent. 7 members voting in the affirmative.
7 members voting in the affirmative and no members voting in the negative. The motion ought to pass as amended does prevail. The members who are not here, who are participating remotely, may, if they wish to be recorded, contact the presiding officers of the House and Senate within 24 hours, and they will record your vote. With that, Representative Babbage, if you want to just have a seat and hold on for a minute. The next thing we're going to do is to do some language reviews. We have 3 different bills we need to do a language review on of matters that we dealt with last week. LD 2153, which is the Drug Overdose Review Panel. We don't have that in front of us. If anybody has a question, what we're going to do here is we're going to try to go through this these matters expeditiously. If anybody has an issue or a question about the language, then we certainly will have Peggy go over that with us. LD 2153 is the Drug Overdose Death Panel. Right, you should have all received all of these by email. Peggy, why don't you just briefly indicate what we did here? Oh, this, okay, do we need an FYA review on this? Tom, have you done that? Representative Harnett indicates that he has already done the Freedom of Information Act.
Right.
Review is required. Go ahead.
There's actually a stack of all these amendments as well as Representative Harnett's memos on these bills in the front of the room, and I'd be happy to, I see Senator Bellows is finding the stack. The top of the stack is a memo from Representative Harnett. So LD 2153 is the bill that Gordon Smith brought to you, and you made some changes to it. One was updating the Office of Behavioral Health. For all the members that are on this panel, this is a panel that's going to look at a select group of overdose deaths. And you changed the makeup of the panel, updated the name of the Office of Behavioral Health. You limited it to 1 representative of families affected by drug overdose deaths. And then you added in a person in recovery from substance abuse disorder appointed by the governor. You made sure that appointments to the panel must take into consideration the racial and ethnic diversity of the state. And then you also wanted to make sure, you changed the first date of the meeting to happen no later than January 1st, 2021. And you wanted to make sure that the population, the deaths that are looked at, take into consideration the racial and ethnic composition of that population of overdose deaths. And defined accidental drug overdoses means those overdoses that are presumed to be self-administered by an individual and excludes any overdose that occurs within a licensed healthcare facility. And because you didn't change the confidentiality provisions. Oh, you did. It also strikes out access to confidential criminal history record information. So the panel will not have access to that. And because the bill itself provided confidentiality for the procedures and the records of the panel, it does create a category. It's a new proposed public records exception. Representative Harnett had the opportunity to review it and went through the matrix, all the questions, and I don't want to put words in his mouth. He has his memo. It seemed consistent with the other review panels that have been approved.
Are there any questions by members of the committee with regard to LD 2153, the language? If Representative Harnett?
I just want to add, we don't have those memos in front of us, but it is prepared, the fuller menu review. So just read those, and if there are any concerns about the conclusions I'm suggesting, please let Peggy know. Thank you.
Other questions or comments before we move on to the next one? The next LD is 2160, the PFAS bill of Representative Ingerson's. We have a
Right.
majority. report and a minority report here. Go ahead, Peg.
Right, and I don't have the votes from people who weren't in attendance other than Representative Cardone, who asked me to put an amendment together. So the majority amendment was just to add Representative Ingerson's amendment to make clear that it wasn't intended to affect the Tort Claims Act, both the notice of claim, which is 365 days now, and the statute of limitations, which is 2 years. So that was the majority report. The minority report, Representative Cardone said she wanted to keep that language, but then she also wanted to do a piece of the amendment that was recommended by the insurance folks, which was to limit the discovery rule to only manufacturers of PFAs. And so that's what the minority amendment is. And I did send these out on Monday.
Did we vote on, oh, I have a spider. Did we vote on, no, we didn't vote on Representative Cardone's amendment.
No, right. So she submitted a minority report. She was not there, but as any member of the committee can submit a minority report within the time frame. And she told me right away that, and I think she had argued for this amendment in the first place, so it shouldn't be a surprise. And so she contacted me right away and said this was the amendment she needed. I did share this with everybody on Monday.
Wait, Representative Cardone, do you want to weigh in?
Yes, Peggy, I'm fine with that amendment as you drafted it.
Okay, thank you.
So at this point, we have a majority report, which is ought to pass as amended with Representative Ingerson's language, and a minority report, which does or does not include Representative Ingerson's. It does.
It does.
And then would specifically limit the application of the discovery rule only to the manufacturers.
Correct.
Okay. So what we will do.
Well,
go ahead.
I don't know that you need to revote it.
Okay.
But if anybody who's on the majority report wants to change,
okay, all right,
then you could reconsider and do that. But otherwise, I think this is just a language review.
Representative Babbage.
Thank you, Mr. Chairman. Peggy, can I ask you or Representative Cardone, I don't have the paper in front of me and I actually misread the Cardone amendment but when you say you change the discovery rule only for manufacturers, meaning that the date of discovery, the clock for the 6 years takes place from the date of discovery for manufacturers, but from the date of what would be the alternative?
Well, the act or omission, whatever it is that causes liability. So what that's saying is it's keeping the status quo now for everybody but manufacturers.
Yes. The intent of this bill was absolutely to go after the manufacturers. And I understand that tort law was explained to be very protective. Yet if tort law was totally protective, then there'd be no opposition to limiting the entire thing to manufacturers. So I guess what we're talking about, if, you know, an amendment that I had intended to put forward, barring what I saw on the day that we discussed this, was that barring a threshold of negligence on the part of municipal water companies or sewage districts, more likely, that they too would not be the subject of the change. So I'm asking for clarification on the level of liability of a sewer district that for 20 years, under the guidance of Maine's, acceptable policy, distributed sludge at different farms across the state in a mutually agreed to operation. And now we find that it has PFAS contamination. I understand we now test sludge, but as of what, last year? So Barbara, perhaps you can weigh in on the impact of your amendment.
Representative Cardone, do you wish to respond?
I don't see that it has any impact. I don't see that it changes anything with respect to water in sewer districts from what the current law is.
Right, they're shielded by the Tort Claims Act.
I'm fine.
Okay, thank you. Thank you, Representative Bailey. I turn the microphone off when I want to speak and turn it back on when I want to be silent. Seems to me something's wrong here. Other comments or questions by members of the committee? If not, and you don't think we have to vote this. All right, so if you wish to change your vote, we would somebody would have to move to reconsider, and then from the majority side. If everybody's okay, we're just going to move on. Thank you. The next bill we're going to look at is 2168, which is the racial profiling bill. That needed an FOA that's already been voted. We needed a Freedom of Information Act review, which I believe has been done. Representative Harnett, you want to chime in?
Again, you will receive a memo as to the reasons that I recommend that it meets the exemptions from the Freedom of Access Act. It's a bill that is designed to protect, to enhance the recommendations of the Attorney General's office to collect data regarding racial profiling. And in the memo, I also lay out the reasons why it needs to be confidential. It will still be reviewed by the Office of the Attorney General, who will report out the data absent the confidential information. And again, if you have any questions upon reading the memo, please let Peggy know and I will address them.
Any questions or comments from members of the committee? And this is not one we have to vote again, correct, Peggy?
Correct.
Thank you. That will conclude the language review. I'm sorry, Senator Bellows.
I just have a question about the amendment. The aspect of the amendment that says the name and identifying information of a law enforcement officer or any other individual involved in any activity for which information is collected and compiled is confidential and may not be released to the public or disclosed to any person except as necessary to comply with this chapter, or if it is information relating to a particular person. Does the "is necessary to comply with this chapter" address if there's being a complaint brought about a particular officer who may be engaged in systemic and ongoing profiling, that being used for potentially evidence in a proceeding or challenge to that officer? Because it's presumably in compliance with this chapter, or are we creating a confidentiality clause that shields individuals from liability for profiling?
Representative Harnett.
And I will let, I'll be interested in hear from our analyst as well, but this was just purely as to the collection of the data. And the data would then be used for developing policies, regulations, and best practices for law enforcement agencies moving forward. There is no intent to exonerate or keep somebody immune from civil or criminal liability based on profiling, which is already prohibited in statute, the statute that was enacted earlier this year.
And if I could, I just want to say that language came from the original bill, 1475. And I think there's still a process for the Attorney General to be developing a complaint process that was passed during the first regular session. So, I mean, I think you recognize that this bill establishes the baseline, and between now and when the data is supposed to be collected, there will be quite a lot of work done by the Attorney General in consultation with a lot of folks who have experience with this, and they can make whatever recommended changes, or they might recommend some legislation to change how all of this works. But this was your baseline to get it going and to put it into place. So if there needs to be more development of a complaint process, or if somebody decides they want to follow the Connecticut practice, which is where the officer at the time that they stop somebody, they say, here's how you complain about if you think you're a subject of racial profiling. That's not part of this, but it certainly could be written into the procedures going forward.
Senator Bellows?
I'm not suggesting, yeah, I definitely, when I suggested the amendment last Friday, I wasn't suggesting that we create a new complaint process. I think my question goes to, we know there's already one active suit alleging racial profiling in a particular instance or with a particular person. And I guess my question is, when it says necessary to comply with this chapter, if a lawsuit were brought in a court of law, generally the courts are looking at pattern and practice, but pattern and practice is really hard to establish without data. And so I just want to make sure that in our attempt to keep this data confidential, which I understand from a privacy perspective, we're not shielding it from use in the ordinary court proceedings that might arise if there is wrongdoing. And so I guess the question I have, Peggy, is where it says, except as necessary to comply with this chapter,
right?
Does that create the ability for someone to access that data pursuant to a specific alleged violation of the chapter?
I don't think so. This chapter is a new chapter, and it contains exactly what I had sent you, which is, the definitions, what's going to be collected, the Attorney General's rules and consultation, and then this report. So originally, Representative Hickman's bill included in that chapter a prohibition on racial profiling. So it would have made sense to include saying it to comply with this chapter would have included that prohibition. And so that would have allowed use of that information for enforcement or follow-up. I'm not sure that that's true in this situation.
So would it be better to say something like, except as necessary to comply with the law, or except as necessary to comply with the prohibition on racial profiling? I'm trying to just think through.
Right, that might work, to comply with this chapter or the prohibition on racial profiling.
Or even reference the chapter that is the prohibition on racial profiling.
Yeah, right. And I'm thinking that the prohibition on racial profiling is mostly in the law enforcement training provisions.
Okay. So maybe just writing the prohibition on racial profiling is clearer. Yeah.
In order to do that, however, we've got to reconsider the bill because we've already voted. So we're going to have to back it up if we're going to amend it again.
Does it change the intent of the bill? Yeah.
That's fine.
So this is a little bit different situation than we usually have, because you said, here's the minimum we want in the bill. And I went and pulled other pieces from 1475 to make it a full package. So, if you feel like you need to revote, I completely understand. If you're also saying, I did not completely convey your wishes when I drafted it, I'm not sure that needs a revote. However you want to handle it, I will support you.
And I'll leave it up to the committee. If the committee's comfortable putting this clarifying language into what we've already voted, for those who voted for the bill or some version of the bill, unless somebody thinks that we need to do some sort of a formal reworking of it. Is everybody okay with the way that Peggy has explained it? And I think there was a minority of ought not to pass. I'm not mistaken. What was the vote, Peggy? Do you remember?
I don't have the final vote. Everybody that was in the room voted in favor of it.
Oh, okay. And we don't know at this point how people working remotely had voted for it. Okay.
No.
Obviously, if you voted ought not to pass, this probably isn't going to change your vote any. So, okay. Other comments or questions about LD 2168? Okay. Then does that conclude our language review work,
Yes.
Peggy?
Yes, it does. Thank you.
All right, you're welcome. Now. Yeah, by email. We'll get another look at it by email, but my guess is we're not going to see each other's smiling faces again in person for a while. All right, we're going to now move to the 3 tribal bills. As we do, Senator Bellows is going to absent herself from the committee room. Representative Talbot Ross, you're staying with us? Okay. That's fine with me. As Senator Bellows makes her way back to the, I guess they think she's back in the Senate chamber, I would now turn to the tribal representatives and their attorneys. I'm going to go alphabetically as I have them on my screen. Chief Sabatis, would you introduce yourself, please?
Good morning. Chief Sabatis from the Halton Band of Maliseet Indians.
Thank you. Chief Francis?
Hi, good morning, everyone. Chief Kirk Francis from Penobscot Nation.
Vice Chief Dana, I saw you on here somewhere. Lost you at the moment.
Good morning, Vice Chief Dana here.
Good morning. Thank you. I think those are all the chiefs or vice chiefs that we have. Ambassador Dana, would you introduce
Vice
yourself?
Chief New.
I'm sorry. Yeah.
Yes, good morning.
Oh, I'm sorry. I didn't see you, Darrell.
Good morning. Darrell Newell, Vice Chief, Passamaquoddy Indian Township. Thank you.
Thank you. Miss Dana, the ambassador from the Penobscot Tribe Nation.
Good morning, Molly and Dana, Tribal Ambassador, Penobscot Nation.
And I believe we have Representative Newell with us as well.
Good morning, Rena Newell, Passamaquoddy Tribal Representative.
And we have a number of the tribal attorneys. I would begin with Mr. Hinton, please. Corey Hinton, can you hear us? How about the other Corey? Where you're on here somewhere.
Good morning, everyone. Corey Albright with the Halton Band of Maliseet Indians.
Thank you. Yes, Miss Binney, you were back at the beginning here. Yes, go ahead.
Good morning, Allison Binney with the Penobscot Nation.
Also from the Attorney General's office, we have Mr. Taub. Introduce yourself, Mr. Taub.
Good morning. This is Chris Taub from the Maine Attorney General's office.
Welcome. And Ms. Patwatan. I said that wrong. I apologize. Kimberly.
Good morning. This is Kim Pat Warden from the AG's office.
Thank you. And we have a number of other interested parties. I think we'll probably stop there. From the governor's office, Mr. Abello.
Good morning, everyone. Tom Abello.
Thank you. It's my understanding, based upon a couple of conversations I had last night and then with my co-chair today, that there has been some progress toward a couple of discrete items within LD 2094. And I'm looking for somebody to explain to me what the plan is as far as moving forward. And maybe I would turn to Ms. Binney first. I know that you were part of the discussion. What's the best way forward?
So the tribal chiefs have been meeting this week, and the lawyers have been having daily conversations with the Attorney General and Governor's office. So it's right in that there has been progress on a couple issues, definitely the criminal jurisdiction and the taxation issues. I think we're really close on criminal jurisdiction. We are, medium close on taxation. I think there are some, I think in concept, we're all on the same page, but trying to negotiate how to fit that into law is kind of the discussion right now. So we're not quite there yet on taxation, but I think in concept, we are at least talking about the right issues and everyone agrees on those issues. The tribal chiefs feel pretty strongly about the land acquisition issues, and we have not been able to have meaningful dialogue with the governor's office on that yet. The focus has been on criminal jurisdiction and taxation. So yesterday in talking to the tribal chiefs, I think they're mindful of the numerous comments that have been made at the Judiciary Committee about trying to separate out some of the issues from LD 2094 versus moving a large comprehensive bill. And so in yesterday's discussions, the tribal chiefs thought that it probably made sense to separate out the gaming issue. That seemed to be a topic that was brought up at every Judiciary Committee hearing. Some of the other committees, the issue was raised, and there does seem to be concerns about whether and if any of these changes will allow the tribes to connect gaming activities in Maine. And so we on behalf of the tribes have decided to separate out that issue, gaming. And basically, I think Ms. Talbot Ross is going to offer it as an amendment to LD 2118. And that way the committee can just vote and the legislature can hopefully just vote on the gaming issue separately. In addition, the tribal chiefs decided to separate out the two issues in which we've made substantial progress in our discussions with the Attorney General's and Governor's office into a separate bill as well. And those would be the issues of taxation and criminal jurisdiction, with the hope that as this bill passes through committee and moves to the floor of the legislature, that there'll be additional discussions between the tribal representatives and the Attorney General and Governor's office to try to do additional cleanup on the floor of the legislature. I will say that we also added into that bill, today's goal is to add into that bill, the issue of land acquisition. It's one that's amongst the tribes, particularly Penobscot Nation and Passamaquoddy, has been discussed significantly. You guys know that during the work sessions, you've heard about this issue time again. It's a big problem for Passamaquoddy tribe and Penobscot Nation because they essentially do not feel like they have gotten the benefit of the bargain from the Settlement Act. Both tribes were guaranteed up to 150,000 acres of trust land. They haven't gotten over 100,000 acres of trust land, and they just feel like in the past 40 years, that's been one of the key components of the Settlement Act that has not been fulfilled. So I say it because the chiefs want me to make sure that the committee understands how important of an issue it is. But I also raise it because it's not an issue that we have had meaningful dialogue with the governor's office on it. It's our understanding from the governor's office that they have heard from municipalities about concerns with land acquisition. We're not sure of the extent of those concerns. I'm not aware of any of the municipalities directly reaching out to the tribes, but the tribal chiefs did spend time trying to, through the internet and whatnot and research, trying to understand some of the concerns of the municipality. And you'll see in Ms. Talbot Ross's amendment today an effort to try to address those concerns and to try to move the ball forward and make some progress on that issue. So the goal of today is to separate out the issues of criminal jurisdiction, taxation, and land acquisition into an amendment to LD 1392 and to have those issues move on their own for the committee to vote on today, and then hopefully to have the full legislature vote on that bill. And then the remaining issues will stay in LD 2094 because it's important to the tribes and to the tribal chiefs that given the amount of time and effort that's gone into the task force that came up with the recommendations that led to LD 2094, and the overall intent of the task force and the overall intent of LD 2094, which is to modernize the Settlement Act so that the tribes in Maine are more on par with other tribes throughout the country. That's important that these tribal nations feel like the committee's moving forward with at least those issues as well. So we do hope that the committee will also vote on LD 2094 today as well. We did spend time trying to clean up some of the issues that were raised in LD 2094. Ms. Bellows is going to be offering an amendment to LD 2094, and it's really to address the issues we heard and the concerns we heard during the committee work sessions. And a lot of those issues were just a need to clarify some language and clean up some language from the introduced bill to be more consistent with the intent of the sponsors, but also of the tribal nations. So that's really what the amendment that Ms. Bellows is going to be offering today to LD 2094 does. It's just a lot of clarification and cleanup on the issues. But the hope is that the committee will also vote on that bill as well today.
Thank you, Ms. Binney. I think before we go any further, I just need to make it clear to everybody listening the sort of awkward procedural situation we find ourselves in. At this point, there is no plan for the Maine legislature to return to function until after the first of the year, after the new legislature is sworn in December of this year. I just want to make that very clear. At this point, there is no way forward that I'm familiar with for the Maine legislature to come back into session during the term of the 129th legislature. We've had 2 ballots to call us back into session. The Constitution is very clear. There are only 2 ways the legislature may be called into special session. One is by a majority of the people in the two major political parties in the legislature, a majority in each caucus. Number 2 is for the governor to call us back. With regard to number 2, I have no reason to believe that the governor's intending to call us back. The procedure has now failed twice on a ballot to every sitting legislator to get a majority of both the caucuses of both political parties. So I want to make sure everybody understands that, because at this point, unless something changes dramatically between now and the next 90 days, which is the election, then I don't anticipate any of this legislation will ultimately be voted on by the Maine legislature. So what we're trying to do, 2 things, it seems to me, is to get these pieces of legislation into a place where they could be voted on, or, unfortunately, putting the finishing touches on some agreements that might then be taken up by the next term of the Maine legislature beginning in December of this year after the election. I just want to be very clear about that, because I think among the general population, some of whom may be listening today, there's some confusion about what we're doing. What we're trying to do is to refine all of these pieces of legislation, all of which are important, and to get them into a posture where we could deal with them at the legislature we're back in session. Now, if I understood what Ms. Binney just said, and that the criminal jurisdiction, there's agreement on language for the criminal jurisdiction. And do I understand that Representative Talbot Ross has an amendment to deal with that particular section?
That is correct, Mr. Chair. I am humbled and honored to submit an amendment to LD 1392 for your consideration today with consent of the tribes. And I believe you have the amendment before you.
Let me ask the next question. So is there a separate amendment also, I believe, from Representative Talbot Ross dealing with the issue of taxation?
Thank you, Mr. Chair. That is true.
Okay. So two separate amendments that we'll have to take up here and look at and talk about. And then.
Can I just double?
Sure, absolutely.
So the amendment to 1392 includes both the criminal jurisdiction and the taxation recommendations.
One amendment, one document, correct?
One document, it has a 2 on it.
Okay. And
Excuse me, Mr. Chair.
I'm sorry. Oh, and land acquisition as well.
Yes.
And right.
I think I was going to say, I think that's right, Mr. Chairman. It's Allison. It's I think it's 3 issues. It's taxation, criminal jurisdiction, and land acquisition. And I just want to clarify that we did not get sign off on those from the Attorney General's office and the Governor's office. I just don't want the committee members to have a misimpression on that. We are super close on criminal jurisdiction. We are at least in agreement in concept on the taxation issues. I think that the disagreement there is really about trying to do the amendments in the implementing act versus doing them in state law. And it's incredibly important to the tribal nations that those amendments be done to the settlement act. But in concept on the issues of sales tax and income tax, there's agreement. And then on land acquisition, this is a proposal that is being requested of the tribal nations, particularly the Passamaquoddy and the Penobscot Nation, as it's critically important to them, but also to Holton Band. So I just want to make sure the committee members understand that this amendment, which encompasses those 3 issues, is being done at the request of the tribal nations.
Thank you, Ms. Binney. Mr. Taub, would you like to weigh in on that?
Thank you, Senator Carpenter. So we have not seen the amendment. So I really am not in a position to make any comments about it. Ms. Binney's correct that over the past couple of weeks, we've had a lot of productive discussions about the criminal issues and the tax issues. And we actually did get to the point very recently of sort of drafting up some potential language on both those issues. But I don't, because I haven't seen the amendments, I just have no idea whether those amendments capture what we talked about or whether there's some differences or not. So I think Kim and I would really need some time to take a look at the amendments before we could really offer any helpful comments to the committee.
Thank you. I'll come back to that. Representative Bailey.
Thank you, Mr. Chair. 2 just clarifying questions. The first is, I do have the 2094 amendment. The other 2, I think I've seen in an email, but I don't actually have in writing in front of me. Am I the only member who doesn't have them? Okay. So I will need to find, do other people have them? They do. It's under the calendar. Okay, I will find them then. But second.
Representative Bailey, it's on the table down here at the.
Oh, it's up front, Chris?
Yes.
Okay, thank
where
you.
you testify, yeah.
Okay, thank you. I can find them down there then. But secondly, the other clarifying question, and this is for Ms. Benny or whoever can answer it, is the 3 issues that you're dealing with, criminal jurisdiction and land acquisition and tax. Have you also then taken those issues? I know you mentioned when you talked about gambling, and we've got that amendment. You mentioned then you took gambling out of 2094 to deal with it discreetly. Have you also taken out criminal jurisdiction and land acquisition and the tax issues out of 2094, or have you not?
We have definitely taken out gaming out of LD 2094 because it seemed to be the issue that came up the most during the work sessions. The land acquisition provisions we do leave in LD 2094, and that is in large part because we've not had a dialogue with the governor's office at this time. And so we want to, by doing it as doing land acquisition as an amendment to LD 1392, but leaving it in LD 2094, the tribes have done that to keep open all opportunities to continue dialogue with the governor's office on that issue. So that is land acquisition is in both bills. With respect to taxation and criminal jurisdiction, I'm going to ask my colleagues, the two Corys, to remind me just because been a lot of drafting and writing, so I don't want to misspeak.
Before we go there, Corey, could somebody get the copy of this amendment to the Attorney General's office and to the governor's office like now? I mean, I don't see how we can deal with this unless they have this paperwork in front of them.
I did just email them. It'll take some time for them to print it and, look at it. But yes, I did send it to them.
Mr. Arbello, if you are in the building, you are more than welcome to run down here and grab a copy of it. Might be the quickest way to do it. I mean, I don't see how we can deal with this without having the other side involved.
Thank you, Senator. I just got the email, so I will print it out now.
Thank you. I guess I'm going to look to the Corys and or Ms. Binney, and we're going to run this work session in a pretty freewheeling way because we haven't been part of the negotiations or the discussion. So I see a couple of folks have their hands up. I'll call on you in just a minute. I guess I look for somebody from the tribal side to explain to me, logic may be the wrong word, but the reasoning behind, you have two items that you're close to agreement on and one that you have no agreement on, the land acquisition piece. To put those all in the same amendment doesn't seem to me to be prudent. Maybe I'm missing something. It would seem to me that the land acquisition, if we could work out language the committee would agree with, we could put it in. But if you lump three things together, two of which you almost got agreement on and one you don't, you risk the whole thing going down. Just a question, I guess.
So, Mr. Chairman, this is Allison. I defer to the chiefs if they want to jump in here, but the reason why we did it that way was we hadn't gotten far enough along on the taxation issue with the governor's office that we felt comfortable that they could support an amendment or LD 2094 on the taxation issues. The tribal nations feel very strongly that any amendments made have to be made to the Settlement Act. And that's because any amendments made to the Settlement Act have to have the consent of all the tribes and the state, so all the parties. Making amendments to the state laws with regards to the tax code of the state and not the Settlement Act just really leaves the power and leverage with the state and future legislatures to make changes without consent of the tribe. And that just remains a fundamental principle of the tribes. So because we hadn't gotten to agreement on that issue, and because the tribes feel so strongly about having a dialogue about land acquisition, at least land acquisition, they wanted to pit those two issues in with criminal jurisdiction, since we've gotten the furthest on criminal jurisdiction. And so the hope is, even if the committee passes out that amendment to LD 1392 today, that those are the three priority issues where the discussions continue with the governor's office and the attorney general's office today until if there is a special session. And that's why the tribes basically have asked that those three issues be encompassed in an amendment to LD 1392. Those are the issues that they think progress can be made on this year, some meaningful progress and hopefully some agreement. We left them in LD 2094 because we don't know what's going to happen in the discussions. So if future discussions before a legislative session gets called back turn out to make sufficient progress on the taxation issues, but maybe not the land acquisition issues, we want the ability to make further amendments to LD 1392 without jeopardizing those issues being taken off the table for next session. So keeping them in LD 2094, which still remains a more comprehensive bill because it deals with issues such as fish and game, but also civil jurisdiction, which is much more complicated. We need to leave those on the table for the next session. And so it was important to the tribal nations to have them still in LD 2094 as well. So that's the thinking. I think had we gotten closer on taxation and to a place where taxation was in the same place as criminal jurisdiction, the mind frame might have been different of the tribal nations. But given that land acquisition is just so important as taxation, they want to keep those three issues together.
And if I could add to that, Senator Carpenter.
Sure.
Just with respect to taxation in particular, well, let me take a step back and say that we have been having very productive dialogues with the governor's office and the attorney general's office. And I really want to thank them for their attention to this really significant, important set of issues over the last week and a half. But with respect to taxation, we didn't receive a proposal from the governor's office and the attorney general's office till 45 minutes before our noontime meeting yesterday. And we had to react very quickly. And so what we put forward largely includes everything that the attorney general's office and the governor's office has sent to us. But it includes effectively our versions, or I guess, supplements to the language that would better meet the tribe's objectives. With respect to land acquisition, Allison already stated how important land acquisition is to the tribes. And we feel very strongly that there must be continuing dialogue about that issue. What you'll see in the amendment actually comes directly from, to a very large extent, the conversations that we had with the Attorney General's office. We recognize that the geographic scope of trust acquisitions for Passamaquoddy and Penobscot is of concern. We've heard those concerns. The language that was put forward includes a geographic restriction that essentially confines the area where Passamaquoddy and Penobscot will be putting land into trust to their ancestral territories, and that's defined by counties. What that effectively does is say that the tribes can put lands in the trust beyond those very narrow tracts of land that were identified in the Settlement Act. And there is already material in the record submitted by the tribes to say that those lands that are specifically identified in the Settlement Act were largely discarded industrial lands that were made available because they were of no value to the most of the corporate owners that had held them to that point. So by including a geographic area defined by county, the tribes have expanded ability to put lands in the trust within those areas in northern Maine. It's also very important to note with respect to local consent that this proposal requires for many acquisitions the consideration of local input and requires actually the reaching of agreement between the tribes and municipalities. So if you'll look in the amendment, you'll see that with respect to the Penobscot Nation, there's a requirement that land acquisitions within that carefully defined acquisition area not be allowed to move forward within a municipality unless there are agreements on issues such as land use and taxation. With respect to the Passamaquoddy tribe, we include that same exact language, the same exact geographic restrictions, again, specifically intended to address the concerns that we heard from this committee. But Passamaquoddy tribe is in a slightly different situation. We've heard testimony that the tribal chiefs and myself have said on multiple occasions that the drinking water situation at Tibaig is an ongoing public health crisis. We view the need to put land in the trust as absolutely critical to our ability to bring forth a tribal solution to that problem. No solutions have been coming forth from anywhere else. We view land acquisition as a key to us being able to self-determine our future and to deliver clean drinking water to our people. Therefore, for the Passamaquoddy tribe, what we've included is a special provision that would be a new paragraph in the definition of Passamaquoddy Indian Territory. And that paragraph essentially says that where the tribe owns fee lands currently, the tribes can put those lands into trust. This is specifically intended to avoid the very difficult, dangerous, and really painful process that the tribes have had to go to put land in the trust in the areas immediately around us. Now, we know that these are discussions, proposals that have not been fully vetted by the Attorney General's office, but as you hear them recount it to you all, I think you'll all recognize that what we're talking about here are very calculated proposals that are reflective of the discussions that we've had both in this committee and really with the Attorney General's office. We heard the need to preserve local consent. We heard the need to geographically restrict trust acquisitions to the tribe's Aboriginal territory. And we also heard concerns with gaming. LD 2094 has been revised to specifically address all of those issues. So I'll stop there and leave it to my other colleagues to address the other questions. Thank you.
Mr. Taub, would you like to weigh in on those issues? Well, on the discussions, I know you haven't seen the language, but, or Mr. Arbello, either one.
I'll just be completely honest, Senator. I mean, I just received, 68 pages of proposed legislation, and it's, I mean, to say that it hasn't been fully vetted by the Attorney General's office, I mean, that's something of an understatement. I mean, this is the first that we're seeing this language. These are incredibly complicated areas. Again, I mean, I apologize for this, but I just can't even begin to offer any helpful comments to the committee unless we've had time to take a look at this language. It looks like there are some things that are consistent with sort of the discussions that we've had, but there's some other things in here that just, and I'm trying to sort of pay attention to what's going on in the committee and at the same time sort of flipping through what's been sent to me. So it's really hard, but there do seem to be some things that are consistent with what our discussions have been, but there also seem to be some things that we haven't talked about before. So, I mean, all I can say is that if you want the AG's office to be helpful in this situation, we really need some time to pour over this stuff.
Representative Evangelos, you have your hand up.
Yes, sir. Thank you, Mr. Chair. So I'm just thinking about where we were in this room about 10 days ago. I'm committed to, enacting reforms, but I'm also committing to getting it right. And to the chairs, it looks like we need more time again. People need to be talking and consulting. Here we are again, up against an artificial deadline. And, to the chairs, yesterday, the Chief Executive's office came out with the budget projections where we're going to stand for the next 18 months. And for the current fiscal year, $500 million, $500 million. And it sort of seemed like that they were going to need to call the legislature back in to deal with that. So, Mr. Chair, I mean, can't we ask a yes or no question of the governor as to whether we're going to be called back into session? I mean, we're traveling blind here, without guidance. And it's not fair to any of the participants who are making amendments and proposals and want to talk to each other that we're going to be, shutting this process down or voting on this process when further consultation might be advantageous. But, I understand separation of powers, but it is a simple yes or no question. Are we going back into session and when? I mean, it's not unreasonable. We're asking the same thing of our leadership in the House and the Senate. We saw the results again yesterday. I'm not going to get into a political gamesmanship over this. I voted yes to come back in to take care of all of our business. But if we're $500 million short, it looks to me like the legislature might have to come back in to deal with that. So why can't we get a yes or no answer on that so that everyone who's participating in this call today can be given the guidance necessary as to whether or not we can keep talking, produce, the amendments with consultation, or whether we're just gonna, throw the towel in today and vote. It's hard. I mean, how can we not get an answer to that simple question? We're asking the same thing of Senator Jackson and Speaker Gideon, and they're answering. They put a poll out. So that's a request that we seek guidance from the Chief Executive as to yes or no, are we coming back into session and when, and then we can work around those parameters. Otherwise, we're just going in circles.
Senator Bellows, I'll come to you in a second, I guess, and I'm not being flip. I'm not being a wise guy. The silence from the governor about session, I think as of today says no, we're not. I mean, I think, and we can, you're welcome to ask to send an email to the governor's office or go in and talk to somebody and ask them specifically. But I mean, I think the fact that there's been no indication from the governor's office that they're likely to be calling us back into session, and I don't anticipate that they will be. I don't have any secret information to the contrary. So I think the silence, in fact, it is speaking for itself. Senator Bellows?
Thank you. I just want to respond not to the issue of whether we go back or not, but to the issue of the consideration of the 3 bills before us. We just voted out some similarly complex racial equity and justice concepts, and we did so after less deliberation in hearings and work sessions than these 3 bills before us have received. So I recognize that there is a lot of history here, over 200 years of history, and going back to the Settlements Act, 35 plus years of history that complicates the discussions. And I don't undervalue the historic significance of what we are trying to do here in terms of reshaping the relationship with Maine's Wabanaki tribes and recognizing the inherent sovereignty that tribes across the country, with the exception of Maine, enjoy and is recognized. And so in terms of the language, last Friday, we voted on 2 incredibly important and complex concepts without precise language. We voted on the principles, we had shared agreement, and then today we reviewed the details to make sure that those adhered to the shared agreement and votes that we made. And so when I look at the 3 proposals, I want to commend the chiefs and the tribal attorneys for thinking very thoughtfully and giving us an option so that we can weigh in on what I think everyone might agree is the most controversial provision, and that is gaming, so that we can weigh in separately on provisions where there's some substantial agreement with the governor's office, and also to allow us as a committee to vote on LD 2094, which, just as a reminder, and I know everyone in this Zoom call knows, but just to remind the public and those listening, these recommendations for LD 2094 came from a task force led by our chairs with robust participation from all levels of state government and tribal government. Those recommendations came to us in an original bill that had multiple hearings, which is unusual in the State House. And then I brought forward an amendment on March 5th that reflected some of the content of those discussions that occurred during the hearings. And now we see a revised version that when I look at I understand what Mr. Taub means when he says 68 pages of legislation, but when you evaluate the highlighted pieces, which are the changes since last March, those are much more narrow and limited in scope and substance and more easily digested. And so it's not really fair to say it's 68 pages of brand new language, because that's just not simply accurate. It's amendments to language that we have discussed over hours and hours of work session, more than any other issue that we've addressed. And granted, this issue is, again, in its historic significance in the relationships of our state and the tribes, elevated certainly in terms of its complexity. And at the same time, it's really important that we act and that we don't let process stand in the way of principle. So I would just urge all of us today to treat these bills like we treat every other bill and get to casting votes, even amid the uncertainty of whether the legislature will reconvene. And just to reinforce and amplify what Ms. Binney said, I think the reason it's important that LD 2094 in its revised form include everything except for gaming is so that if we do have to start anew next January with a different legislature where some of us may be here and some of us may not, I don't want that future legislature to be confused about the comprehensive and inclusive nature of this legislation. So I would hate to exclude points like criminal jurisdiction or taxation or land acquisition where we think there might be agreement now. And then when a new, fresh set of legislators is looking at this next January, have a piece or element of those get lost. So I think there's some utility in having a bill that is more broadly inclusive. So I will be voting yes today to the amendments before us. And certainly if in language review, there are some changes that merit tightening up language to more accurately reflect the substance of our goals and conversations, then I would be open to that. And if we needed to, as we did this morning, reconsider something because in the interim between now and the time that we next meet, we find something that is really substantive, I'm open to that as well. But I don't want to go home today and throw up our hands and say the process wouldn't let us move forward, because the tribal attorneys and the tribal chiefs have done a remarkable amount of work. And many people in this room, including Senator Carpenter and Representative Bailey, have been in this, doing this work now for over 2 years. And I think we need to acknowledge and honor that work and move forward.
Thank you, Senator Bellows. Representative DeVoe, you have your hand up.
Yes, thank you, Mr. Chair. To both of the previous points, a couple things that we need to keep in mind, and I mentioned one of these the last on Friday, is that it seems that it's a continuous kicking the can down the road. So I wanted to give kind of a history, let everybody's clear about what has actually been taking on or going on, and then how long it's been going on. So for those who don't know, 213 years ago, the very first treaty that this nation ever signed was signed in Waterton. And it was with the tribes of the St. John Valley, as they were called then, and the Micmacs. 169 years ago, the creation of the state of Maine was given the authority from, in the agreement from the state of Massachusetts, that they would take care of the tribes in order to receive the $30,000 that they were promised for becoming a state. 31 years ago was the original 1989 Maine Indian Claims Settlement Act. And then last week, one of the things that was discussed was some issues about not being able to properly have dutiful consultation and meaningful dialogue due to COVID. And then today we got at 9:06, I received, as the Attorney General's office mentioned, 68 pages of legislation to look at. And while I understand Senator Bellows want to get this done, my problem is that I haven't had a chance to read through this 68 pages. And that's been an issue that I've had this whole time that I've been serving in legislation, is that just because you hand me something that's supposed to be the same as last time, I want to read and verify. With that, and the knowledge that we're not going to be coming back unless something changes drastically at the governor's office, what prevents us from having another meeting Friday and allowing the AG's office to actually read through the 68 pages, allowing this committee to read through the 68 pages, and allowing the bills to be presented and to be brought through. Now, I understand that those of us that are in support of these bills, we want these to go through, and we do. I have to be able to look at the 68 pages and in good faith, know that they haven't changed from the last Friday. I have to trust but verify. So please keep that in mind, that for the past 213 years, the tribes in Maine were promised one thing, but given another. Thank you.
Thank you. I'm trying to figure out what the best way to proceed here is. And I think, first of all, there may have been, I haven't counted the pages, but as Senator Bellows has indicated, the important language is that which it proposes to be new. One possibility is for us to take a break from this particular issue, let the folks begin to digest what has been negotiated, what has or has not been agreed to, and then we can argue over that. We also have, if you look, the committee amendment number 1 in the upper right-hand corner is a separate issue. This is the gaming issue. So what we could do is to turn to that while people are looking. Again, I don't think we're talking about 68 pages of new anything. There are some changes in there, and that's what's been negotiated. Excuse me. So I would propose, it's 10:30 exactly. I would propose we would take a break until 11 o'clock exactly. At that time, we're going to come back and deal with committee amendment number 1, which is the gaming piece. I mean, that looks to me to be fairly straightforward, yes or no. It simply carves out an exception. And that would give people a chance to review the changes in what is now committee amendment number 2. And then we'll go forward from there. I'm not set in stone on that. It just seemed to me to be a way to proceed. I plan to be here all day. I'm in no hurry. In response to Representative DeVoe's position, I do understand the frustration, John. However, I don't think, we asked last week for an additional day, and we were granted. The Speaker and the Senate President gave us today, especially in light of the poll, which has come about since we were here last, which indicates that we're not coming back into session by legislative call anyway. Then I would be very surprised if we get another day. And I do think that almost is the definition of kicking the can down the road. The tribes and the governor's office have been negotiating. We've heard from both sides that those negotiations have been done amicably and have had some success, not as much as maybe any of us would have liked, but some success. And that hopefully will continue on. But I don't think we would be granted another day. And so I don't know that that would be worthwhile. I would urge the committee members and the people, the participants, to look over the changes to LD 13 as proposed, LD 1392, which would be the criminal jurisdiction for the taxation piece and the land acquisition piece. And we'll be back at 11 o'clock.
Mr. Chair.
Oh, I'm sorry. I didn't see your hand. Yeah, go ahead. Representative DeVoe, go ahead.
Mike, I guess my concern would be, is that enough time for Mr. Taub and Mr. Bello to be able to go back and confer that those are actual things that they're going to be able to accept?
Well, my hope would be that they would have time. Again, they've been part of the negotiating process right along here, and we're going to shift gears when we come back anyway and deal with committee amendment number 1. So they actually have longer than a half hour. And if not, then we'll give them more time. Representative Harnett, you have your hand up.
I do. Thank you, Mr. Chair. You mentioned that if we follow your suggested course, we will come back and look at Amendment 1 and Amendment 2, but there was no reference to Amendment 3, which is the original bill,
Right.
2094.
Right.
I just want to make certain that will still be on the
Right.
table for today.
I would anticipate that we will take up LD 2094 as probably the last item today, but we will take it up.
Thank you.
All right, we're back at 11 o'clock.
looking for the rest that I had frozen. It's gone. Well, I'm gonna order some more. Go to Small House, but I'm afraid they won't have them. You're thinking what?
All right. 11 o'clock. I'm proceeding on the assumption that, there we go, Senator Bellows is there, Representative Babbage. We're back to where we were when we left. Mr. Taub, have you had a chance to review? No, SkySat, disregard that. Continue to review. I said when we came back, we would start with committee amendment big number 1, the gaming, and the procedure here would be that we're going to strike everything in LD 2118 and use that as a vehicle to create an act concerning gaming under the Indian Gaming Regulatory Act. And what this amendment does, it amends the main implementing act to make clear that the tribes would be subject to the Indian Gaming Regulatory Act, and nothing in state law would prevent them from operating under IGRA. Peggy?
Hi.
There you are. All right.
Yes. Sam's on the call too. So, so we were just talking about if you want to go forward with this and you're still relying on the, because you're not amending the federal law, you're saying, I think you probably need that language that we're counting on working about. It may not be deemed or construed to affect or preempt the application of the laws of this state. In order to take IGRA out of
It'd be nice when I can get back on this and not
that prohibition or the, I can't remember if it's 16B. It's in 16B of the federal law. I don't know if that was intended to include that, or maybe it was considered not necessary. But we don't.
Yeah, whichever one of the tribal attorneys came up with this, would you just address Peggy's issue?
This is Allison, Mr. Chairman. We like Peggy's issue. We just aren't sure that the governor and the attorney general want to do what Peggy's suggesting. But obviously the tribes had proposed an LD 2094, and I believe it's still in their language that would basically say that the state takes the view that nothing in the state laws impact or I forget the exact language. One of the Corys might have it, but basically that the federal beneficial acts would apply to the tribes in Maine. Because we didn't have agreement on the language regarding the federal beneficial acts, we decided that it was best to draft this language specific to gaming that basically says that the state's taking the view that nothing under state law is intended to alter, limit, or prevent the tribes from being able to conduct on their reservations or trust lands subject to the restrictions in the federal Indian Gaming Regulatory Act. So we were essentially trying to be mindful of the concerns raised by the Attorney General's office and governor and do a narrow fix to just the gaming issue.
Questions? Peggy, are you okay with that now?
Well, I mean, sure. That's, of course. I don't know. We don't know. Even if you have that language in there, we don't know how it would be interpreted.
Correct.
So if you want to go forward with this language without the may not be deemed or construed to affect or preempt, I can see that argument. So, sure.
But I can see the counter argument as well.
Yeah, and it may be that if this bill passes the legislature and gets signed into law, that there's likely to be litigation. Given what we've heard during the course of the work sessions that this committee has held, is there's likely to be litigation on anything related to gaming, regardless of what language we pass. So we really drafted the language to try to be mindful of concerns we heard from the Attorney General and Governor's office on the broader language of federal beneficial acts applying to the tribes in Maine.
Mr. Todd, would you like to weigh in?
Thanks, Senator. Yeah, so the first thing I just want to flag, I know that we're not talking about, I guess it's Amendment 3, the amendments to 2094, but I feel like I have to say this now because there is some sort of interplay. And that is, I think I heard the intent of the amendments to 2094 was to carve gaming out of that, but our quick read is that it doesn't. So the amendment to 2094, as we read it, would not carve gaming out. So I just want to put that out there, and if we want to come back to that at some point, we can do that. But so just looking at 2118, I think that the issue there is the issue that Peggy flagged, which is that, and this kind of goes back to the discussions that we had during the task force and in some of the work sessions, which is that it's not clear to us whether the state can simply say that something is going to be subject to the Indian Gaming Regulatory Act when the First Circuit has held that the Indian Gaming Regulatory Act does not apply in Maine. So I think the risk of this language is that it would authorize the tribes to conduct gaming activities, but the provision that would limit that to the Indian Gaming Regulatory Act would not apply. So you would have gaming, but you wouldn't have the guardrails of the Indian Gaming Regulatory Act. And so, when Allison said about how litigation is likely, I mean, our view is always that if we can avoid litigation, that's always a good thing. And so I think that the fix in this situation would be, because there is some uncertainty about whether the Indian Gaming Regulatory Act can be made applicable in Maine, the solution would just be for the Maine legislature to basically create its own version of the Gaming Regulatory Act. In other words, it would establish what the guardrails are for the tribes to conduct gaming activities. So instead of just sort of leaving it up in the air about whether IGRA would apply or not, the legislature could simply sort of impose its own guardrails on Indian gaming. But if the legislature doesn't do that, then the risk is that there would be no guardrails.
The only thing I would add to that, Mr. Chairman, is that there's not an instance in this country where a tribe is conducting gaming outside of the Indian Gaming Regulatory Act. And while I understand what Mr. Todd is suggesting, it is in principle something that the tribal nations do oppose, which is being subject to restrictions placed in state law and having their sovereignty subject to state law instead of being treated on a government to government level. So while I definitely understand and recognize the need to limit litigation, and that is one of our goals here, with respect to gaming, over the course of the work sessions, it became clear to us that that's probably not the case. But I also, in representing the Penobscot Nation before the federal Congress, have pretty good confidence that if in fact this law got signed into law by Governor Mills, the federal Congress would actually take it upon themselves to either amend the federal act or not amend the federal act and do a standalone bill that would be consistent with this bill to make sure that the tribes in Maine are subject to the federal Indian Gaming Regulatory Act.
Senator Bellows, your hand up.
Ms. Benning said that more eloquently than I ever could, but I think, again, all of our conversations today are grounded in the fundamental concept of sovereignty. And so I appreciate Mr. Taub's suggestion from a strictly legal perspective, but I think that it would be a mistake to codify this by introducing that language. We would essentially be codifying some of the same problems that we're trying to fix with regards to recognition of sovereignty. And the only other thing that I would say is that a quick search of our statutes does demonstrate that in other places in statute, and maybe this isn't applicable, and this is where I not being an attorney is a challenge, but we do reference federal law in other places in statute. So while I'm sure good attorneys on all sides could disagree in a court of law, the reference to saying subject to the Indian Gaming Regulatory Act does not seem completely inconsistent with how we've treated references to the federal law in some places in our statute.
Thank you. Other comments or thoughts or questions about this before we vote on it? I'm looking for a motion from somebody. Representative Harnett. Whoops, sorry. Representative Babbage, you have your hand up.
Thank you, Mr. Chair. Yeah, we'll talk about gaming right now. Obviously, I've had huge concerns all along. How do we honor the tribe's desire to be recognized as sovereign nation, and protect 1.3 million Mainers from a situation that could develop that in which we're treating some of our Maine citizens with preference over others. And, I have to say, as a teacher, having taught the tragedy of Indigenous Americans, every year, trying to have students understand and empathize with the story and the consequences and so forth, I am struggling with this whole concept of sovereignty. Sovereignty, as I taught it, was ultimate authority. I'm sorry, but no tribe has ultimate authority in this country. So some of the academics have written about subordinate sovereignty. Well, that's a new concept to me. I think it's about self-determination, but self-determination also can have guardrails. And the UN Declaration of Rights for Indigenous People doesn't talk about ultimate sovereignty. It talks about self-determination and shared sovereignty. So to me, what I want to do is to really honor our Native people with the dignity they deserve, with the self-determination that they deserve. But I'm in an unusual position of having to make a decision, unlike any other decision I've made in 5 terms, that a subsequent legislature, even with the aid of the governor, cannot correct. So, with regard to, let me tell you my worst case scenario with all of this. I'm fearful. I've never been a friend of casinos. And even though we're talking about tribal sovereignty, this bill is about money. And money is necessary, and I'm not, nobody needs to apologize for that, because money is necessary for self-sufficiency, and self-sufficiency is integral to sovereignty. It's important to all of us. But how do you get to this self-sufficiency? And in my case, I'm worried about, and it's the old worry, but it's one that I've had all my life, that there'll be out-of-state interests that are looking for an attractive investment, one in which state regulation and state taxation doesn't apply. And so I might have as my neighbor a casino that is run by out-of-state interests and perhaps owned in name only by the tribes. I mean, the result that I want here is not that the 5,000 natives or whatever it is that we have in our state merely prosper and receive their checks in some southern climate, while we in Maine here are left with the remnants of something that I'm not in favor of. I don't believe in philosophically, and that's gambling. I mean, I've never thought that drugs, gambling, or prostitution were economic plans. And you know, that sounds outrageous perhaps, but we've had a tribe request the right to have a brothel. That at the time, the one that I was reading, the federal government said, well, that's not really what we had in mind for economic development. But understand the tribes. The tribes themselves debate the morality of these kind of pursuits, but poverty is the real thing that drives them to these kinds of decisions. And so I'm afraid I'm just not going to be on the same page here with gaming, because I think the ulterior, not the ulterior, but the perfect storm for me is unlimited tribal acquisition with the inability to regulate gaming. And so I mean, let me give you a little bit of history here. Is remember how gaming happened in this state. In 2003, we had and way before that, we had many proposals regarding gaming. As a matter of fact, the Penobscots were involved very early. We know after the land claim settlement, since Maine law prevailed up here, we know that they were instrumental in helping the Pequots get started, get organized, get started. They were hired by the Pequots to evidently run their operation for 4 years, and the thing went so successful that the Pequots bought them out, and the rest is history. We have the largest casino in the world and one of the most prosperous, and it has saved southeastern Connecticut economically. But of course, the Penobscot Beano operation was something that I always thought was good for them, you know, $10,000 super prize once in a while. But, you know, in 2003, we had a casino proposed for York County. And to give you an idea, the Maine defeated the proposal 2-1. York County was 27% yes, 73% no. My town of Kennebunk on that York County proposal was 14% yes, 85% no. There's no question how we felt about York County. It's not needed for economic development. It's not an element that we need to have in our community. But on that very same ballot in 2003, slots were offered as for harness racetracks. Everybody in the state knew that this was a bill to have slot machines at Scarborough Downs. But the big debate was this casino in York County. And so there were a lot of Mainers who said, no on this casino, slots, who cares? Scarborough Downs, that's a sequestered campus. Sure. Well, the town of Scarborough didn't, so it passed. The town of Scarborough did not allow this to go through. They voted it down. And Bangor said, we'll take it. We have a harness racetrack. And that's how Hollywood got started in Bangor. 7 years later, the Oxford Casino was proposed. By the way, that slots for Scarborough Downs, everybody thought, but slots for racetracks, that was actually passed by the state of Maine, 52-47. That's what got us into the casino business that we're in today. In 2010, the Oxford Casino passed in a state referendum by 50.4%, 0.8%, 50-49. And that's how we happen to have Oxford. Kennebunk did vote 43% for Oxford and 56% against it. So even though it was a 13-point loss in Kennebunk, that's a lot closer than it had been. In 2011, there was a casino in Lewiston proposed, and Maine voted it down by 63-36. Again, Kennebunk was 31% yes, 69 no. And then finally, in 2017, the casino in York County, Maine overwhelmingly opposed it. York County overwhelmingly opposed it. And in Kennebunk, it was 86% no. So we have gaming in Maine by the skin of its teeth. And let me read your quote here. The casino idea is flat out bad for Maine. It would conflict with Maine's clean outdoor family image. It would promote addictive behavior. It would steal workers from other employers. It would raise state spending and would prey on poor Mainers who cannot afford to gamble, but would do so anyway. Those are the words spoken in 2002 by Angus King. So that pretty much is where I come down on this. And so I just wanted to clarify that putting this in some sort of implementing act in any way takes away the state's ability to make a change. And so I will not be able to support it. So I just wanted to share where I'm coming from with all of that. And I appreciate you tolerating my background. Thank you.
Thank you. Other comments or questions, or Representative Talbot Ross?
Thank you, Mr. Mr. Chair. I must admit that after 4 years of participating, almost 4 years of participating in this body, of which I feel honored to do so, I'm struggling with a response to pick up this conversation and place it back where it should be. And I'm concerned about the meaning behind some of the words that were just used because of their absolute failure to understand the cultural and economic genocide that has taken place in this state and in this country for hundreds of years. I'm struggling with how to understand the ability to use the word sovereignty and self-determination in the same stream of consciousness with 1.3 million Mainers shouldn't be subject to preference of one group over the other. I mean, that is, I'm struggling with how to put those concepts in one stream of consciousness because it means you don't understand what sovereignty means, no idea what self-determination, and no recognition of the original sin in this country back in 1492, the American genocide. I want us to get back to understanding how we got here. In all due respect, the fundamental goal of the task force recommendations in LD 2094 was to modernize the settlement acts with the main tribes in order to put their authorities and powers more in line with the authorities and powers of tribal nations across the country. And that is absolutely dependent on our acceptance of their sovereignty and their ability to position the tribes as with the state as government to government. So while I respect my colleagues' attempts to see gaming within the realm of self-determination, I must say again that in the over 3 years that I've been here, I cannot think of any other time when systemic racism has been so significant to our understanding of how to move these 3 bills forward. We must do better. The time is now, Mr. Chair. We must do better. I will remind everyone that the tribes were invited into this process. They did not come to the state and ask us to go down this road. We invited them into this process. And to now get to a place of such disrespect for what work they've put into this over the last 2 years, I must again say what I offered the last time we were here, and that is my apologies to the tribal leaders and members who have, in all of this work, have compromised, have shown up every time, have negotiated in good favor, have waited and waited and waited on the state to just respond. So I apologize to them. And I ask that we move this bill forward, LD 2118, as amended. I ask that we motion to move this forward. Thank you.
Should turn my microphone on. Chief Francis, you wanted to weigh in. My apologies.
Just real quickly, thank you, everyone. I just wanted to make a couple of points about what we're trying to do here and why. I think the task force in its mission was very clear about being grounded in the principle of not only respecting tribal sovereignty, but promoting and fostering a more sovereign to sovereign, government to government relationship that could be productive for all Maine citizens. When you look at this issue in general, there are no more examples. I don't know where I am on gaming locally. I don't know where our people are on gaming locally. But I do know that our people stand for the principal right to make that decision for themselves. But I will tell you this, that there's been no more example of an inequity in this state than this issue when it comes to the tribes and gaming, which Congress passed a federal law, which was a restrictive law, as the committee and the task force knows. This was not a beneficial law to tribes, which brings me to my point about guardrails. Guardrails, the Indian Gaming Regulatory Act actually mandates a conversation between the state and the tribes where a compact has to be reached. That compact has to be in full agreement by everyone. The state has a right to say we're not signing that compact. And I'm not aware, and Ms. Binney and others can articulate this better than me in terms of the law, but I'm not aware of any situation in the country where a state has objected to a compact and a tribe has rolled the state over on that issue. That's just not happened. The National Indian Gaming Commission, which is housed in the Department of Interior, who has the regulatory oversight of these facilities, allows for no more than 30% interest by outside entities into an Indian casino. And I understand the concern about in name only and all that. And that's something, quite frankly, in the current condition, Maine should be concerned about, because that's exactly what we have with those two commercial casinos. We have outside entities that hold a large stake in that business. A lot of that money leaves the state. And I'm not criticizing anybody for their structures of their businesses, but that's exactly what we have. As we've also learned in the task force, the tribes of Maine aren't going anywhere. We've always been here. We would argue quite factually that these resources would almost predominantly stay in this state. And so I understand the history of this. The Penobscot Nation had gaming in 1979, and it was taken away in 1980. That was class 3 gaming, by the way, we had. And I understand the history of where we've been since the early 90s, in talking to the state about restoring those gaming rights, which has not happened to date. I was very aware of how gaming became a situation in this state, because on the same ballot that created the approval for 6 miles from our current gaming operation, where we were only allowed to do high stakes bingo, we were defeated 2-1 on that same ballot. So I'm very aware of the history. And in terms of, brothels and prostitution, I think we can all agree what a deplorable path forward that would be for anyone, especially considering the disparities in trafficking of Indigenous women and murdered and missing Indigenous women. That, quite frankly, is appalling today in this country. So the tribes are trying to find a responsible path forward that promotes a government-to-government relationship where we both build a product that is about people from Maine and about resources staying in Maine, and about a structure that we all truly have a say in. And IGRA provides that, and that's the reason the references for IGRA, because that was very important to the other task force members as well. And I just wanted to add those points. Thank you.
Thank you, Chief. Representative Harnett.
Thank you, Mr. Chair. I'm a little confused as to where we are right now. There was a motion made by Representative Talbot Ross, and it has been seconded. Okay. And I will be voting in support of that motion. And I simply want to point out that this amendment has nothing to do with the morality of gambling or how one feels about gambling. What it does is it gives the right to the tribes of Maine, a right that is enjoyed by tribes all around the country, to make economic decisions on their own. And those might include the ability to set up a compact with the state to run gaming operations. I don't see the laws saying you have to run a gaming operation. It simply gives that right to the sovereign. And I just want to pick up on a point made by Chief Francis. In the beginning, we heard that this would favor the tribes over the 1.3 million Mainers. The tribes have been shut out of gaming completely. And they were voted down by Maine people. Maine people saying, we don't respect or recognize your sovereignty. The 2 casinos that we have in Maine now, Oxford is owned by Churchill Downs, think Kentucky Derby, nothing to do with the state of Maine. And the Hollywood Casino in Bangor is owned by Penn National Gaming, an out-of-state corporation. I frankly would prefer people that have been in what we now call Maine for thousands of years, who have not gone anywhere, controlling those investments to benefit themselves and the people of the state of Maine. So I will be supporting this motion in the strongest way possible. Thank you.
Thank you, Representative. Representative Babbage, you have your hand up.
Sure. Am I on already? Thank you. Yeah, first of all, you know, Representative Talbot Ross is one of my heroes. She's a 24/7 crusader for wonderful causes, for people. But she doesn't need to apologize for me. I will do that when I need to. When I'm talking about Maine citizens, I'm also talking about Native Americans. I don't believe they're surrendering Maine citizenship in this process, even though we're talking government to government. My concern about gaming is merely the formula that we inherit. And I'm talking about the Cabazon case in 1988, which is a good case. I agreed with it. But it puts us in the situation of if we go by the federal rules, then yes, then natives can have gaming in any state where the state has already made it legal. We've done that. So I am concerned very practically about the impact on our state with regard to how many casinos and where and all of that. And I don't know all of the details of this, but my concern is the fact that the formula has been set up that if we give up our place at the table, and I understand this consultation, but I do not understand that there needs to be permission. If we give our place at the table on this and go by federal rules, then we're in a situation where I think I don't want to give up that place at the table to look at what's good for all of us. I mean, you know, please understand, I'm evolving on gaming myself as far as you know, class 1, class 2, class 3. I think Miss Binney made some comments about even lower level gaming can be very important to a tribe and so forth. And I'm open to all that, but I do see this formula, and please understand, I have made a lifetime of teaching about injustice in the American story. And so I understand that. I did have a Native American woman come to me after one of our judicial hearings and say to me, "Are you going to help the poor Indians?" Now, I didn't know if I was being mocked or not, but in our conversation, what I agreed was that what I want for our Native citizens, just like I want for all of our Maine citizens, is access to a wonderful education and health care. Those are real things that can make progress. If we're talking about gaming, which we do have in 2 casinos now, then maybe the answer is that 25% of all profits from current casinos go to the Native tribes. I mean, those are laws that we can change because that's not part of any implementing act. But there are different paths forward here. It's just that I have major concerns. And really, I want to vote on gaming as part of a package so that I know that if I'm okaying gaming in this sense, if I therefore that can't control the tribal land acquisition proposals, then that worst case scenario that I told you about that worries me could in fact happen. So So that's where I'm coming from, and it's not from any lack of empathy or understanding. And I have to say, every time Chief Francis speaks, I'm touched by the dignity and the wisdom. So, thank you.
Thank you. Representative DeVoe, then Senator Bellows, and then Representative Record. Representative DeVoe, go ahead.
Thank you, Mr. Chair. First, I'd like to point out a glaring issue that I see going to be coming up in our next vote is that we have an appearance of bias for individuals who have casinos in their communities that they may that I don't want to come up, and I don't think that they should be allowed to vote because they have casinos in their communities and could obviously be swayed one way or another. Second, I would like to ask how many of the communities that have casinos in them have a signed treaty for over 200 years? Next question I'd like to ask is why is it that the towns and municipalities should be given any more authority to have economic advantages over tribes? And then to touch on the self-determination part, the self-determination within the state only comes with government-to-government relations and the Maine's duty to consult. These are things that are not even being discussed, and there's more fear-mongering coming than anything else in this. And I agree. I hate this. It might sound odd, but I will be supporting this wholeheartedly because the Maine tribes are no different than you, Representative Babbage or Senator Bellows or anybody else that's in this community. They are voting members within the state of Maine, have the same rights and more because of the treaties that that our forefathers have signed. And the simple fact that the fear mongering and the what ifs, well, guess what? There's federal guidelines in place in order for the state and the tribes to work together on gaming. And if the AG's office and the governor can't figure it out with the tribes, then there's also other ways to take care of that. Now, we've seen a number of unconstitutional bills passed just because they can be passed. And then what has to happen is then there has to be harm proven in a court in order for there to be action taken from that. Now, this is no different. We have a bill that, yes, could be legally challenged in court down the road. I think that we need to give, finally, the tribes that opportunity to take an opportunity and decide themselves, not legislation, to do the right thing. We would do no different in a community that we all live in. All government should be at the lowest form. We're passing this to the tribes to be able to do it right under the federal guidelines that the state would have to enact as well. And with that, I'd like to move to vote.
I believe that Representative DeVoe has just moved the question. Is there a second? Seeing no second. Representative Record. Be patient, Senator Bellows. I'm coming back to you.
Oh, good. I was going to say she was ahead of me. So,
Yeah. Very spoken. So I'm.
all right. So that's fine. I'll be happy to respond. Listen, I have to say, I've been listening to this debate myself for close to 4 years now, and sometime before that as a citizen. And there were a couple of things that Chief Francis said today that really resonated with me. One of which was his remembering the Indian women and prostitution issue. And I applaud him for melding that into his testimony because I feel so strongly about it myself. But the piece that struck me first was the words he used, and I couldn't tell you exactly what they were because I was driving home from the hospital in the passenger seat and I couldn't write anything down. But basically, the words I heard resonated with me as a woman who spent practically my entire life working for a woman's right to choose. And whatever it was he said resonated with me in that same tune. And I thought to myself, we're talking about the Native Americans' right to choose whether or not they have a casino. They may choose not to, as I think was indicated by somebody who was speaking, might be the case. And I think that and people who have choose to indulge in that activity, which frankly, I don't choose to indulge in my own self. I mean, well, actually, that's not true. Once in a blue moon on a cruise, I'll take $20 and that's it. When I lose it, it's gone. But the point is that it's a personal choice issue. And because of the centricity of the sovereignty issue for Native people, I think it's every bit as critical as I feel a woman's right to choose about whether or not to have a child is central to my being, whether or not I ever made that choice or ever chose not to. But I feel like the sovereignty issue is core in the same kind of way, probably more so, frankly, because it's been around for thousands of years. And the right to choose only been debated for probably hundreds. So my point is, I think that this is a choice issue, and it's a choice issue of the people who would be housing whatever that casino is or whatever that bingo hall. I don't care what it is. I don't feel that I can make that choice for the people who live in that area and who would benefit from it. I think that's theirs to make, not mine. And so I too will be enthusiastically supporting this bill, and just want to make the record clear that for I think the fourth or fifth time now, Representative DeVoe and I have been loudly on the same side of an issue, and I just want that recorded for the future. Thank you.
Senator Bellows, and then back to Representative Babbage.
Thank you. And I just wanted to say, the reason it was important to me, and I know we are not talking about LD 2094 yet, but to have a separate conversation about gaming is that I do see gaming as fundamentally connected to sovereignty and the larger issues we're discussing. And at the same time, there are sincere and deeply held beliefs around and arguments for and against gaming from a civil liberties perspective, a religious perspective, an economic perspective, that I think evoke strong emotions in people. And like Representative Babbage, my own views on gaming have changed over time. One of the pieces of work that I'm most proud of the legislature for doing this summer is applying the racial disparity analysis to the bills before us under the leadership of the Permanent Commission on the status of racial, ethnic, and indigenous populations. And the structure that we have with gaming in our state, whether it's the lottery, the main lottery, or the casinos in Oxford or Bangor, regardless of intent, and we could argue about intent, the impact of that is a white supremacist structure, and that white gaming authorities are permitted to exist and indigenous are not. And so I will be voting for this motion. When we get to 2094, I want to talk through with the attorneys how we can separate the gaming issue out and keep it in this bill so that this bill can be about a conversation about the myriad arguments around gaming. But I just want to echo Representative Talbot Ross and thank the chiefs and tribal attorneys for being at the table, because we invited you into this conversation this time. This is not something that we are doing at your request, and you've had remarkable patience in educating us and working with us on how to do this in a more equitable and just way. So thank you for that.
Representative Babbage.
Yes, thank you. Oh, I've got it on. Yes, and when I brought up the tribe with regard to I don't exactly know what the wording they used or whatever, but it was basically a brothel. That was Nevada. Nevada had legalized prostitution already. My point being, two points, I guess. One being, money drives our survival. And sometimes when we don't even need it, we go after it. But there is no doubt that we're talking about a population of people who are deserving. And I was actually having empathy with the small tribe in Nevada that had to resort to that kind of proposal. But we do have a situation with the Cabazon case in with regard to gaming. To me, that dictates an outcome that I'm not happy with, and that's just. I mean, yes, I want to help, but not at all costs. We can do this in a better way. And I'm not even saying that I'm that close away from approving something like this if I could see it in a package that, and honestly, I can't claim all wisdom here. I have put so many hours into this. I have read Wilkinson and Hoaxie and Neil Rold, my good friend, who I never realized wrote such a wonderful book on the history of Native Americans in Maine. You know, I'm just saying I'm still learning after months of reading and reading and reading. And the opinions that I'm giving today are not from, there's no conspiracy going on here. I've not been, I've chosen to come upon this myself trying to find truth, but I haven't been to the governor's office. I haven't been, I mean, seeking out their input, at least in that regard. So don't think that I'm representing anything but my own points of view, my own concerns. But that's where I'm coming from. So I will be voting no.
Thank you.
Just because I'm not there yet. That's simply what it's about. Thank you.
Thank you. Motion pending before the committee is ought to pass as amended 2118. The amendment being now the bill, if you accept it. It's the one that has the big number 1 in the upper right-hand corner. Any further discussion of the amendment or of the motion? If not, I would request that the folks here in the building make their way to the room 228 so that we can have a vote. After that, we're going to break for about an hour for lunch. We're going to come back and we're going to take up where we left off, hopefully with the amendment number 2, if you will. Okay. I'll wait for the members to make their way to the chamber, to the room. I'm answering a question from a committee member. Right. My response, I'm almost done, was, the question was asked by a committee member whether people would be able to vote if they had a casino in the district. And my response was, I didn't believe that the ethics rules require that the mere presence of a casino would require recusal, but I indicated that he was free to ask the Ethics Commission. All right. We have the 7 members in the room. No further discussion. I would request the committee clerk to call the roll. Pending motion is ought to pass as amended.
Thank you. Representative Cardone. Representative Cardone is absent. Representative Harnett.
Yes.
Representative Harnett votes yes. Representative Evangelos.
Yes.
Representative Evangelos votes yes. Representative Curtis. Representative Curtis is absent. Representative Reckitt. Representative Reckitt is absent. Senator Bellows.
Yes.
Senator Bellows votes yes. Senator Carpenter.
Yes.
Senator Carpenter votes yes. Representative Bailey.
Yes.
Representative Bailey votes yes. Representative Babbage.
No.
Representative Babbage votes no. Representative Talbot Ross.
Yes.
Representative Talbot Ross votes yes. Representative DeVoe.
Yes.
Representative DeVoe is absent. Senator Kime. Senator Kime is absent. Representative Hagan. Representative Hagan is absent. 6 members voting in the affirmative, 1 in the negative.
6 members voting in the affirmative, 1 member voting in the negative. The motion ought to pass as amended does prevail. A reminder to those who are on the committee but remote, the 24 hours to contact the Speaker or the Senate President's office to record your vote. Sorry about that. With that, we're going to break until 12:45. 12:45, I'd ask you to be back. We need 2 other bills we need to finish up here today. Thank you.
Yep, I can hear you already.
Hello? Problem solved?
I think so.
Oh, wait.
If somebody from IT can hear me, I'm not able to get in. I don't care about you. Oh, hold it. Maybe it's connecting now. Here we go. Thank you, IT person in the sky, whoever you are.
If somebody's from IT is listening, Chris Babbage down in taxation would like to print something from his phone, but it's not picking up something. So I could use some help if you know how.
I know it's 12:45, but we're still awaiting the arrival in the committee room of a couple of people, two of whom just wandered in. Thank you. All right, we're back. Are you there, Peggy?
I am. I'm here. I'm trying to help Chris, Representative Babbage print.
Oh, I'm sorry.
Oh, no, that's fine. He hasn't sent it to me yet.
Okay. So I got a text from you at lunchtime saying something. That
Yes.
there was a potential conflict. Go ahead.
Right. It was just a potential conflict if, because I know you're going to be very successful in all your work, both 2018, which you just voted on, and the amendment to 2094 both pass, it's kind of set up a conflict about IGRA. And just kind of, we think the way it's worked, we in our office, Sam, Janet, me, think you would need to change the wording a little bit to make it clear that the 2094 amendment doesn't rule out IGRA. It just doesn't apply to IGRA, if that makes sense.
So
we will be happy to bring it up when you get to that.
Okay, there you go. We can fix it when we get to 2094. Okay. So if we have folks back on, and it looks like we have most of the players from this morning, let's go back to 1392. And let me ask the players if over the course of the last few hours, anything has changed. And I guess I would turn first to Miss Binney, if she's here.
Senator
Hi,
Carpenter.
Go ahead. Yeah, you're not here. You're in Washington.
If I may, thank you, Senator Carpenter. Ms. Binney has another obligation that, at least for the moment, is going to be keeping her away from the committee, which she regrets. But Mr. Hinton and myself are available to talk to the respective pieces of LD 1392 in whatever order the committee wants to take them. But I will also say, to answer your question, I think more directly, in the last hour or so, I don't, from the tribal perspective, there's no sort of new information there, although we're certainly prepared to help walk folks through the amendments that are reflected in LD 1392.
Thank you. Mr. Taub, you want to weigh in? Have you had a chance to look through the paperwork associated with 1392?
We've started to look through it. I mean, we've flagged some concerns and some issues, but I wouldn't say that we've exhaustively looked at it. And I don't think, these are all complicated issues, and it's very hard to analyze this kind of legislation and figure out what all the consequences are going to be without taking more than a couple hours of looking at it. So we've done the best that we can in the time that we had available to us. But I just don't want to lead the committee to believe that we actually are in a position to really give fully informed advice at this point, because we're not.
Thank you. Peggy, you want to walk us through the proposed committee amendment, which says number 2 in the upper right-hand corner?
Well, you know what? I'm not familiar with the amendment. We just, stuck it into our document. I'm hoping that maybe Mr. Albright or Mr. Hinton can walk you through it step by step.
All right. So either of the Coreys wants to begin?
Sure, thank you. I'll get started. And then when we get to the tax part of the legislation, I'll turn it over to Mr. Albright. Just starting at the top of the document, the legislative findings and declaration of policy are, I believe, precisely what were in 2094 in the version that was pending up until today. So there's been no changes there. But in general, as the legislation states, as far as the declaration of policy goes, the purpose of the amendment is to establish that the tribes enjoy all the rights, privileges, power, and immunities of other federally recognized Indian tribes. Moving through to page 3, 4, I'm looking for the first changes. The first changes, new language would appear on page 5 of the PDF. And these would be changes to section 6205 to the definition of Passamaquoddy Indian Territory. The changes on this page and that carry over into the section related to the Penobscot Nation, the Penobscot Indian Territory, would generally provide that the tribe's area where they are authorized to acquire trust land would be restricted to the counties of Penobscot, Franklin, Hancock, Piscataway, Somerset, Washington, and Aroostook. And with an exception for the Passamaquoddy tribe that I'll get to in a moment, the amendment provides that no lands within a municipality can be added to the Penobscot territory or the Passamaquoddy territory without agreements in place between the respective tribe and the relevant city or municipality. And there are 3 agreements that are specified here as being necessary for a fee to trust acquisition. The first agreement would require an agreement to ensure that there are payments made in lieu of taxes that's equal to the amount of taxes that would have otherwise been levied. This is similar to the structure that's in place when lands must come out of trust. These are references to the so-called pilot payments, payments in lieu of taxes. 2, there must be an agreement for cooperation and mutual aid regarding which government will be responsible for law enforcement. And 3, there must be an agreement between the respective tribe and municipality to ensure that the lands are not used in a manner contrary to local zoning ordinances. So these 3 agreements are intended to specifically ensure that for the most part, lands are not going into trust unless there's agreement on taxes, on mutual aid for law enforcement purposes, and for zoning purposes. There is an exception from this for the Passamaquoddy tribe that I'll get to in a moment, but just before I close on that, I forgot that there is a provision, paragraph C on page 6 at the top of the page. You'll see that if the agreements for taxes, law enforcement, and zoning are not in place within 90 days of when the tribe notifies the municipality of the intent to proceed with the land acquisition in trust, the party could be submitted to arbitration. The dispute would be submitted to arbitration. I just want to note that this notion of creating a framework for reasonable decision-making in the land acquisition process, this came directly out of a discussion that the tribal attorneys had with the Attorney General's office. Chris Taub and Kim, they actually came up with this idea of ensuring that there's some requirement of local consent for trust acquisitions while putting in some limits to ensure that those acquisitions are being considered in a manner that's reasonable and fair to the parties. With respect to the Passamaquoddy tribe.
Mr. Hinton, just one quick,
Yes, sir.
small matter. In line 4 of paragraph C, I think you left out a word. I think the word submit should be after the word party, perhaps.
Okay. Yes, yeah, that's exactly right. Thank you, sir. Yeah, that's a word that would need to be submitted there. Small typo. But the point is that there are substantial efforts made for a multi-month period between the tribe and the municipality to work out the issues that are most relevant to trust acquisitions. And the 3 required agreements are they are specifically intended to address the concerns that we've heard from this committee. We've heard concerns about zoning. We've heard again the reference to the 5 acres in downtown Portland and a casino tower going up. That would squarely be prohibited under this. So these agreements are really intended across the board to address the concerns that we've heard local governments raise. So that's what that is intended to do. With respect to the Passamaquoddy tribe, however, it's very important to note on page 7, there's a new paragraph F that would permit the Passamaquoddy tribe to place into trust fee lands that it currently owns without a requirement of local consent. And this is those land acquisitions, those trust acquisitions would still need to be made within the Aboriginal territory set forth above. So this would be in the northern half of the state, southern Maine, York County, those counties, Cumberland County, those counties would not be eligible for these acquisitions. But this language here is specifically intended to address the very critical risks to human health that the Passamaquoddy tribe has raised since the beginning of this process. Those primarily go to the drinking water situation and our inability to access drinking water supplies on lands that we already own. And there have been other concerns raised about the need to provide for other critical infrastructure projects. So here, this would provide that the tribe can put its already owned land into trust. And then moving along, there are several pages of this PDF where there are no changes that have been made at all. And I'm just scrolling to the tax provision. Corey, do you want to take over on the tax part of this this proposal on page 11?
Sure. Thanks, Corey. And maybe before I do, I'll just pause to see whether or not, any members of the, well, I'll defer to the chairs, obviously, on how to proceed here, but I'm happy to start on tax if that's what the chairs would like.
Yeah, go ahead for now. Yep.
Okay. Okay, so I guess what I'd like to do first maybe is just start with a little bit of context so that you understand the approach that was taken with the amendment with respect to tax. As Ms. Binney indicated this morning, or maybe it was Mr. Hinton, we received from the governor's office a draft of proposed tax amendments to Title 36 yesterday, just before lunchtime, about 45 minutes before we were going to jump on a call with them to discuss. So we got something concrete in writing from them just yesterday around midday. And so what we then did was on the call with the Attorney General's office and the governor's office yesterday, and we did have a very good conversation. We undertook to ask them a number of questions and to just kind of poke and prod and feel out, some of the language that we were going through quickly and reacting to. And Kim and Chris did the best they could to answer the questions that we were raising, as did the governor's office. And we were certainly appreciative of that conversation. So there was, based on the proposal that we received yesterday, there was a couple, major concerns, one of which the chiefs have spoken to many times, including earlier today, which is wanting to memorialize these principles in the implementing act. And I guess what we've then done is viewing this as a first step. We sort of view this as a first step tax bill. What we undertook to do then yesterday afternoon, following the conversation with the Attorney General's office and the governor's office, which, and they are well aware, and we discussed the importance and the priority for the tribes of having this be part of the Settlement Act. What we undertook to do, and which we had discussed with them on a prior call, was to essentially, within the general framework of the tax issues that they were looking at and discussing, making changes, corresponding changes to Title 30, to the implementing act. to reflect the same subjects. And so that's what the amendment does. Is it's a first step, and I mean first step in the sense that this tax bill, this amendment, does not undertake to address all of the tax issues that LD 2094 does. It addresses only certain tax issues, specifically sales tax and income tax. So that's what is here in 1392 is a first step on taxes. And I do not believe that anything in LD 1392 is inconsistent with the tax provisions of LD 2094. But what 1392 attempts to do is to take the proposal from the governor's office and to create corresponding language for the implementing act. So that's the background. And now I'll just go ahead and so walk through. And so on page 11, the first amendment would be to 6208, part of the implementing act. And it would add a new subsection 4, which has been titled sales tax here. But it has a couple components. It provides that the 3 tribes, as well as their tribal members and tribal entities, shall be exempt from sales tax on their respective tribal lands. The second component here is that the tribes and their tribal entities and tribal members shall also be exempt from state income tax with respect to income earned on tribal lands, so long as the tribal member or the tribal entity resides on tribal lands. So both of those provisions, sales tax, income tax, are drafted to be consistent with principles of federal Indian law. I will pause there and note, just to make sure there's no misunderstanding or about where things are at, that the proposal we received from the state yesterday does not include tribal entities at all. It's limited to tribal members and to the tribes themselves as tribes. So we have expanded that to include tribal entities. Obviously, tax is about economic development. It's about growth. And as everyone on this committee knows, the ability to do business in various forms is critical to that. So, you know, we've included tribal entities. The second piece, sorry, is there one, I just want to make sure that I'm clear. There was one other piece that I was going to mention. The second piece was that the proposal from the state as to income tax was limited to wages, compensation for services. And there was a specific definition that was incorporated regarding the definition of compensation for services. So again, that limited the exemption from income tax to only wages. It would have not covered, for example, entrepreneurs on the, tribal member entrepreneurs who may have their own businesses, creating their own products, selling their own art, because those aren't wages. It would not have covered business income that the tribes would be generating through their business entities, which they would like to reinvest in their communities and services. So that is an area where in this proposal, in this amendment, we have expanded on what the governor proposed yesterday, the state through the governor's office, and as we discussed. So I want to be clear about that. But those two principles about income tax, about sales tax, tribal entities, these are grounded in LD 2094 and in the task force recommendations. Subparagraph B regarding sales tax builds upon an existing provision in Maine law, which is 36 MRS 1815. And that provision in its current form provides for the return of sales tax revenue to the Passamaquoddy tribe, but to that tribe only, for sales tax generated on, I believe it's Passamaquoddy Reservation land. This provision expands that to all three of the tribes. And then the last part of this paragraph refers to a deduction that from these sales taxes that are returned to the tribes that goes into the local government fund. And that's also currently in law with respect to Passamaquoddy, is that current percentage is 3.75% comes out and goes into that local government fund. And all of you will know much better than I do how that all works. But so the tribes have not proposed to take that out. They've left that in, recognizing, the importance of revenues going to their neighbors and to other and local governments. Subparagraph C is a provision that would authorize Maine Revenue Service to enter into sales tax revenue sharing agreements with the tribes with respect to sales taxes collected on tribally owned fee lands. So the paragraph B above, that is limited to tribal territory or trust lands. This paragraph paragraph C would allow Maine Revenue Service to enter agreements into with the tribes regarding sales tax collected on tribally owned fee lands. D is a definition of tribal entity, and that is defined to mean a business entity that is owned by the tribe or their members, where more than 50% of the ownership interests are held by any combination of the tribe and its members, or an entity that is owned by a married couple, at least one of whom is a tribal member. And then the final paragraph authorizes Maine Revenue Service to promulgate regulations that may be necessary to implement this subsection, and indicates that in doing so, they would confer with the tribes regarding those regulations. And that is sort of a catch-all provision to recognizing that there may be implementation that needs to be done in connection with the subsections here in 6208, and that Maine Revenue Service would have the authority to do that. The next section, section 6.
Corey, could you hold on just a minute?
Yes.
As we go through this, it might be helpful if we had the Attorney General's office weigh in on these provisions one by one as we go through. Mr. Taub?
Yes, Senator, do you want me to start from the beginning of the bill?
I'm sorry, what was the question
Well,
again?
so do you want me to, before Mr. Albright was discussing the tax provisions, Mr. Hinton was discussing some of the earlier provisions. I just wanted to know if the chair wants me to go back to the beginning.
Yeah, why don't you go back? Yep, that's fine.
Okay. And again, this is just sort of based on our fairly quick read of this during the recess. I think that the first point I would make is that although this bill is being sort of, it's been suggested that this amendment is only addressing 3 discrete areas: tax, criminal, and land acquisition. There's some very broad language at the beginning of the bill, and this is something that Mr. Hinton discussed. One of which there's language that refers to refers to the purpose of the original Settlement Act as reserving rights that were embodied within the specific treaties that gave rise to the claims at issue. And then there's another provision, this is paragraph 1 on page 2, that says the purpose of the amendments to this chapter enacted in 2020 is to establish that the Passamaquoddy tribe, the Penobscot Nation, and the Holton Band of Maliseet Indians enjoy rights, privileges, powers, duties, and immunities similar to those of other federally recognized Indian tribes within the United States. So if the purpose of this bill is just to achieve those 3 purposes, the land acquisition, the tax, and the criminal, we're not sure why these other provisions are included. And it would seem to us that, especially for that paragraph that I just read, that that paragraph seems to suggest that the tribes would have sort of all of the same rights under federal law that tribes in other states have. So I think in essence, it almost sort of swallows the entire bill because it doesn't, it prevents the bill from being limited just to the 3 specific issues and instead essentially incorporates the entire body of federal law and all the rights that tribes have under federal law. So that's kind of point 1.
Can we talk about that?
Yeah, Representative Babbage, go ahead.
Thank you very much, Mr. Chairman. Well, maybe I've given everybody an idea where I'm coming from because I have big reservations. I want to grant the tribes rights, but I would like to hold on to them as a state law for a period of time to see if it's applied as we hope it would be, and then to make it a more permanent situation. However, when I looked at rights, privileges, powers, duties, and immunities, I was reluctant to embrace this paragraph, but I do want the natives to have the same rights. Well, I talked about a gaming exception, but the same rights that have been implemented to federal tribes, especially during the Obama administration. We had some great things there. So my question to you, Mr. Taub, is what about the word similar? Powers, duties, and immunities similar to those of other federally recognized tribes. Is that binding or is that permissive?
Well, that's a good question. I guess it's hard to predict how a court would interpret that language, but I guess the bigger point is why is this language here? It's not this. If the idea of this bill is just to address land acquisition, tax, and criminal jurisdiction, it's not really clear what the purpose of this paragraph is. And I agree, maybe similar would be read as meaning something different than identical, but then I guess the question would be what's similar and what's not. So I guess what I can say is that this language raises the possibility that that the tribes will have additional rights beyond those that the bill actually addresses. And again, I mean that's a policy call. But I just wanted to make it clear to the committee that this bill, as it may end up being interpreted, may well not be limited to just those 3 discrete areas.
Can I answer your question, Representative Babbage?
Yes.
Okay, why don't you continue, Mr. Taub?
So on the land acquisition.
Excuse me, Mr. Speaker, or excuse me, Mr. Chair.
Go ahead, Representative DeVoe.
Yeah, I know I'm not
I
on.
can't see your hand. I don't even have you on at the moment. Go ahead.
Okay, I just had a question, Mr. Taub. What would be the reason that this would become an issue? This paragraph in here.
Well, the way it would arise is if there's an issue about whether the tribes have jurisdiction or authority to do a specific kind of thing, and then the issue would become whether that paragraph confers jurisdiction on them to do that. So, for example, let's say that the bill involving gaming does not pass the legislature. This paragraph could potentially be interpreted as saying that the intent of this legislation was to give the Maine tribes the same or similar privileges, powers, duties, and immunities as other federally recognized tribes. So does that mean that by virtue of that paragraph, they have the same sort of gaming rights or similar gaming rights as tribes in other parts of the country?
I guess I fairly understand that. I guess my follow-up on that would be, is that my understanding is that this whole, oh, I'm sorry, I saw Corey raising his hand. This whole act is to, my understanding was to work with the tribes and get them equal or similar, as it's written, powers and authorities. I don't see, I guess we're chasing our tail on a bunch of things. So I don't see why that would be a problem. We're trying to work to get the tribes the same powers and immunities as tribes that are recognized by the federal government. That I thought was our intent. If that's the case, then why would we remove something that says we want to give them the same powers and rights of federally recognized tribes?
Well, so that was the purpose of 2094. And this language, this paragraph that I was reading, I believe is lifted directly from 2094. And in the context of 2094, it made sense because as you suggested, the purpose of that bill was to essentially confer on the tribes all the same rights and benefits and privileges as other federally recognized tribes. But this amendment to 1392 is being represented as just involving three discrete issues, just taxation, criminal jurisdiction, and land acquisition. So when you insert something from the much broader 2094 bill and insert it here, it raises the question about whether now 1392 is much broader than just the three areas that it purports to address.
Could you fix that with a simple, this is in, I don't know, you're gonna have to word it in their legalese manner, but what about if you were to say that pertaining to this title and section?
I mean, again, like, you know, we have had less than an hour to look at this language. We are doing the best we can. I guess my suggestion is that paragraph isn't really necessary in this legislation. I don't know that the legislation would become any less effective if this paragraph were removed. Is there other language that we could come up with if we had time? I suspect we could.
And Mr. Chairman, this is Allison, but I defer to the tribal chiefs on this. As Mr. Taub says, this language was pulled from LD 2094, and the only reason why we included it is because we weren't comfortable eliminating it without the committee making that decision, since it was the express intent of the committee when the committee drafted 2094. So Mr. Taub's right. It's just this amendment is only on these three issues, but we understood that the committee wanted to, at least on these issues, get closer to how other tribes outside of Maine are treated. And so that clause, which is in the purpose section of the amendment, so it'd be the purpose section of the bill, is just to be a reflection of the intent of the committee. But, you know, for as much grief as it's, you know, giving the Attorney General's office, the tribal chiefs may be fine with just, you know, eliminating it. It was really more to express the intent of the committee. So I'm not sure that, you know, court wouldn't look at it. The only time a court would ever even consider looking at it would be if the other language of the actual amendment that goes into law, gets codified law, was somehow very ambiguous, and I don't think it is. So it's just really more an expression of intent. So to move the discussion along, it might just be better if the chiefs are okay with it, with just eliminating it. But it was really more of a reflection of the committee's intent in trying to do these three bills.
And if I might add, this is Kim Pat-Warden from the AG's office. There's also in this prefatory language about treaties. And this is something that the AG's office has spoken at length on in front of the Fish and Wildlife Committees, Marine Resources, Natural Resources. You know, it's the insertion of this language regarding treaties from 200 years ago, and whether and to what extent that will change other provisions of the Settlement Act. And also whether or not it would be inconsistent with Section 1731 of the Federal Act, which specifically discharges and releases the state of all obligations underneath those treaties. So again, this is just language that we've flagged in the past. These are things we've said in the past to other committees. Just want to bring them to the attention of this committee because I'm not sure it's been said here. It is in the Attorney General's testimony on 2094. But again, this is another area where this is language that's being brought in from 2094 that is not specific to land acquisition, tax, or criminal jurisdiction. It's again another area where it's broader than what was represented.
Thank you.
Chair Carpenter, if I could, I just want to follow up on that really quickly and say that the intent of 1392 as it's crafted here is specifically intended to address substantive issues in the areas of taxation, criminal jurisdiction, and land acquisition. If you look at the section that has been pointed out, the rights, privileges, powers, duties, and immunities, nothing in here would upset other parts of the Settlement Act that very clearly accord the tribes the status of municipalities in the state of Maine. There are sections of the Maine Implementing Act that are entirely untouched by what's in here. And some of those provisions, 6206 in particular, are the provisions that really do get to the rights, privileges, and immunities of the tribe. And so these statements of purpose and intent are really nothing more than establishing that within these areas that we're looking at, yes, that is the intent, but these statutory sections in that statement of purpose cannot override the explicit language in other parts of the Settlement Act. And quite frankly, to say otherwise, to say that this statement of purpose, which is not a statement of substantive law, would override explicit parts of the Settlement Act, I don't think that's an accurate characterization of how this would be read as far as statutory construction is concerned. So I would just point that out. And just to reiterate Allison's point, the purpose of this legislation, 1392 as it's currently constructed, is not to address treaties, and it's not to address those larger, broader, overarching questions. The purpose is focused on tax, criminal jurisdiction, and land acquisition. And so, I think it will be probably more fruitful if we advance to a discussion of those issues and hear the Attorney General's opinion on those issues, because as Allison said, I think that the chief would very likely be amenable to removing the ambiguity over that, but we don't want to speak for them. I just think that, this intended to focus on the policy issues and not those broader declarations of purpose.
Thank you, Mr. Hinton. Mr. Taub, do you want to go back to discussing the specifics?
Sure. So I think we're at the land acquisition section. And so this is a section that that we had some preliminary discussions with about the tribes in terms of what we could come up with for language that would authorize the tribes to acquire further land. I do want to push back a little bit on Mr. Hinton's suggestion, and I know he didn't say this directly, but just to make sure that that there's no ambiguity. We did not suggest this kind of arbitration procedure for when a municipality or a town, when they're not able to work to enter into cooperative agreements with the towns. We at one point sort of floated the idea about maybe there's some kind of provision that we could have that would address a situation where a town unreasonably withholds its consent. But the discussions really never got beyond that very sort of throwing out the idea. So I just want to make clear that the Attorney General's office never suggested anything like this kind of arbitration procedure. So having said that, I think for the most part, the language speaks for itself. As far as I know, the municipalities have not been consulted about this language. One thing I can say about arbitration procedures is that they can become very expensive. So to the extent that towns are going to be involved in arbitrations over some of these provisions, that is something that could become an expense for the towns and cities. I think Mr. Hinton already flagged this, that there's some Passamaquoddy lands where this municipal sort of approval process would not apply. That would be for all lands that are owned in fee simple by the Passamaquoddy tribe as of August 1st, which the Passamaquoddy tribe requests to have acquired in trust by the secretary. And as long as those lands are within the counties that are identified in the paragraph B. I'm not clear on sort of what the extent of those lands is, but that is an issue that we just wanted to flag, that with respect to the provisions that require the towns to enter into these kinds of agreements before the land will be taken into trust, that's not going to apply to this category of lands.
And also there's a couple of towns that would be also exempted from that. So there's a couple of categories in Calais and in Centerville, to the extent that those lands are acquired. Those timelines have been taken out, and they're not subject to any sort of municipal consent provision under subsection 1 B that was discussed earlier. So it's just a two different sort of two towns that would have no municipal consent provision in any form.
Senator Bellows, you have your hand up.
This might not be the right time to ask this, but I am curious, as we're talking about land acquisition, where the governor's office is on land acquisition. Because last week we heard from Ms. Pissner some desire to work on the tax and criminal justice provisions. I wondered if Mr. Abello could speak to the governor's office's position on the land acquisition.
Mr. Abello, you want to weigh in?
Sure. Yeah. Thank you. Happy to. And let me first start by saying that the conversations that we've had with the tribal attorneys and with the Attorney General's office has been very productive. And so we really appreciate the openness to tackle all these issues, in particular the criminal piece and the taxation piece. Regarding land acquisition, we have not been able to fully vet this new language with the governor or others in the office. I think we're generally speaking open to continuing to discuss land acquisition where that might occur. We did have some concerns that Mr. Taub has already raised, but also wondering about some of the language here with the counties that would be in the unorganized territory, so outside of the traditional municipal structure. And so it's not clear, just one example, but it's not clear about who would be involved in that arbitration, that process by voting. Would that be the legislature that often serves as the municipality for the unorganized territory, or is it something else? And so they're just one example, but we need a little bit more time sort of to vet this, but also, very interested in continuing that conversation.
Thank you. Do you want to continue? Who wants to go next? Mr. Corey Albright or Corey Hinton or Allison Binney? Continue to go through.
Well, I'd be happy to, but Chris spoke up after Mr. Taub spoke up, after I went through the first part of the tax piece. So either Mr. Taub or Ms. Pat Wharton may have comments they want to address before I continue there.
Okay, go back to the tax piece then, if you would, Mr. Taub.
And I think I'll actually turn it over to Kim if she can address the tax piece.
Sure. So again, this is some of this is language we haven't seen before, other than a few hours ago. I will say that there is a portion in here that we did not discuss. I think Mr. Albright indicated that, and that would be sort of the revenue sharing agreements with respect to tribally owned fee lands. That was never a topic that was discussed in between the governor's office, the AG's office, MRS, or with the tribes. So that's brand new today. And there's also a provision in here that I don't think got a lot of discussion, but that's also this section would be 62084A2, and it says the tribes and their members and entities shall be exempt from income tax. The conversation that we were having with the tribes was about individual income tax. This language is ostensibly much broader than that and would apply to potentially corporate income tax as well, which was not a conversation that we had. And there's also no sort of implementing provisions that would be enacted within Title 36 to figure out how that would work. There's a strange, we'll get there, but again, that's an area of exemption from corporate income tax, a conversation that we did not have. We did talk about the definition of tribal entities. The definition, there was essentially no agreement on what the definition of tribal entities should be. And this is also an area that is not dictated one way or the other by federal Indian law. It is an area where there is great variation across the country in how a tribal entity is defined, and how that tribal entity is defined has consequences for broader than just this bill that we're looking at right now. So it was not, I want to be clear about this, is that there were conversations that were going on, And it was not any unwillingness to continue to have these conversations. It was more trying to make sure that there was sufficient amount of time to understand what the consequences of defining tribal entities in a certain way would be, particularly with respect to corporate income tax and the explosion in the last 20 years of the different forms of entities that businesses take now, whether it's partnerships or limited liability companies, and how the flow through of income goes from those businesses. It was really more, at least from the part I think of MRS, was that there wasn't sufficient amount of time to figure out what all the consequences were going to be so that they would be comfortable making a recommendation to either the administration or the taxation committee about what it would mean. So I spoke about this yesterday with the tribal attorneys. This is not an unwillingness to continue talking about this issue. It's just a matter of time and resources available.
So contrary to what I came to believe, I don't think the state and the tribes are very close at all on the whole taxation issue, based upon the language that we have in front of us. Am I wrong? Representative Babbage, get your hand up. Go ahead.
Thank you. Yeah, I want to ask the AG's office, either Kim or Chris, if you know, the tribal entity part of that to me does open up many possibilities. So as you can tell, I'm reluctant to do something irreversible, at least unilaterally irreversible to begin with. So I'm not interested in putting something like that into the implementing act. But I wanted to ask you folks if, you know, in Maine statute, is there a comparable chapter that's parallel to the implementing act? In other words, you know, if we were to adopt something regarding the tribal entities, it seems to me I'd be much more comfortable having that in state law than in something that would be very difficult to change should it not work out the way we all hope. So I guess I'm asking is there a place in statute that this would fit, or you know, the entire proposal for that matter? But I don't know how state statute is arranged and if that would be possible.
Ms. Pat Warden, you want to answer that?
Sure, I can answer that. So the original proposal that was transmitted over to the tribes yesterday had all of these amendments in Title 36. That's where the tax code lives in Maine. So you'll see that there are some various provisions in here that are amendments to Title 36. There's also amendments to the Implementing Act as well. So I think also part of the concern with MRS was, you know, the truncated timeline in which we were working, and again, not understanding or not being able to consider all of the potential outcomes, and not wanting to make a change to the Implementing Act that could not be undone in the future without understanding what the implications of that were going to be. And so the proposal that was made was to amendments to Title 36, with again, the thought being there would be continuing conversations. I'm not sure that this has come up in front of this committee. I've certainly talked about it in front of the taxation committee, but there is also a provision of the Maine Constitution, Article 9, Section 9, that says the legislature shall never in any manner suspend or surrender the power to tax. And so MRS also has concerns about, you know, putting more tax provisions into the Implementing Act in light of that constitutional provision. Now, Mr. Albright is going to tell you that there are reasonable arguments on both sides of that issue, and I agree. There are reasonable arguments on both sides as to whether or not the legislature can, you know, make changes in the Implementing Act to the tax code in ways that would affect the tribes and that could not be easily undone. But it is an issue that is out there, and it's not one that we have a resolution on, and it is one that is of concern to Maine Revenue Services.
Thank you. Senator Bellows, you had your hand up. Representative Babbage still has his hand up.
we may not get to a place of committee unanimity. We certainly didn't on gaming, but I think there's a fundamental threshold question, and I guess this is a question for Mr. Taub and Ms. Pat Warden. And I do appreciate that you have stayed at the table with these conversations and put more hours into this work, probably than almost anyone except for the tribal attorneys and the tribal chiefs. But my threshold question is this. There's a huge difference from a perspective of sovereignty and self-determination between simply amending the tax code and changing the Settlements Act. And it's a significant and important policy question of whether the state of Maine is going to choose to recognize the inherent sovereignty of the tribes and treat tribes in Maine just like tribes are treated in other states or not. I guess my question for the Office of the Attorney General and for the Office of the Governor is, setting aside minor tweaks in language within the tax code, is there a place for agreement? Can you ever agree to changes that are being more permanently through the Settlements Act? Because if we can't, I think that's just important to acknowledge. And then it becomes a question of majority reports and minority reports. Because I certainly, speaking for myself, am interested in trying to rectify what I see as a fundamental significant problem, and that is our failure to recognize tribal sovereignty.
I think Senator Bellows has posed a question that needs to be responded to, perhaps, and if that's if we are at fundamental loggerheads over that issue, then I don't know where we go from there. I don't know how we get over that. So let me pose the question. I see your hand up, Representative DeVoe. I'll come to you in just a minute, please. Is it the position of the state that on none of these proposals are they willing to discuss ways to amend the implementing act? And I don't know, I haven't thought a great deal about it, whether there's some way to do something that is acceptable to the tribe short of amending the implementing act. And if not, if the state just says, no, we're not going to be willing ever or now to amend the implementing act, then maybe we just go forward and take the positions we take and see how it comes out. So again, I guess I'll turn to Mr. Abello or Mr. Taub, perhaps, just to tell me where you folks are on that issue.
I'll go first, I guess, unless Tom, you want to start. But I think, first of all, I would point out that language that we proposed about expanding criminal jurisdiction, our proposal was to put that in the implementing act. So the Attorney General's office is certainly not opposed to making changes to the implementing act. And in fact, that's what we propose doing with the criminal jurisdiction. I think that it's not that we would never agree to put tax changes in the implementing act. I think that our concern, and just to be clear, ultimately it's for the legislature and the governor to decide where these changes go, whether they're going to go in the implementing act or somewhere else in the main code. But what our advice is, we're sort of counsel to the state. And so sort of as cautious lawyers, we remind the state that if you make changes to the implementing act and for whatever reason, you, the state, want to change those in the future, you're going to have tribal consent to make those changes. And so if you want to retain the flexibility of tinkering with things, then you should think about putting them somewhere other than the implementing act. And I think our concern is a little bit heightened in this situation because this is moving so quickly. We are making some of these proposed changes with the tax code, I don't think they've been vetted by Maine Revenue. They've barely been vetted by us. I mean, we've just read them in a half an hour. And so I think it's right to be a little bit concerned about making such sweeping kinds of changes and doing them in a way that is very rushed and puts them in a place where they can't easily be corrected. So that's all a long way of saying that no, we at least for the Office of the Attorney General certainly recognize that the legislature and the governor may want to make changes to the implementing act, and we wouldn't be opposed to that. Our only advice here is that we think some caution is in order, given how quickly this is being done.
Thank you. Mr. Abello, did you want to weigh in as well, or?
No, I would just to agree with Mr. Taub, I think he said it well. I mean, the governor is flexible about amending the settlement acts. But right now, I think where she is on the criminal side, yes, in the settlement acts, on the taxation piece in state statute.
Representative DeVoe and then Representative Harnett.
Thank you. I'd like to pose a question to Mr. Taub or Mrs. Pat Wardian. Sorry if I butchered your last name. At what point did the 10th, Article 10, Section 5 of the Maine Constitution get resolved or amended?
For our enlightenment, why don't you, I don't have a working knowledge of that particular section of the Constitution. What provision are you dealing with? I don't have it in front of me either. What are you talking about?
It states that the new states shall, as soon as necessary arrangements can be made for that purpose, assume and perform all the duties and obligations of this Commonwealth towards the Indians within said district of Maine, whether the same arises from treaties or otherwise, and for the purpose shall obtain the assent of the Indians and the release to the Commonwealth of claims and stipulations arising under the treaty at present existing between the Commonwealth and said Indians, and as the indemnification to such new state, therefore this Commonwealth, when such arrangements shall be completed and said duties and obligations assumed, shall pay to the new state the value of $30,000 in the manner following. That's part of the Section 5 of Article 10 of the Constitution. You won't find it in the Maine Constitution because it's now been taken out of the Constitution, but is still, from what I understand, a active and current constitutional clause. So my question again, when has this or has it been removed, revised, or amended?
As far as I know, it's still in effect.
So with that,
Well, I mean, I would say that, you know, again, this is getting a little bit far afield of some of the issues that we're talking about here. But again, there's also a provision in the Federal Settlement Act that releases the state of all obligations provided to Maine Indian tribes under any treaty. It's Section 1731 of the Federal Settlement Act.
That did not extinguish the treaties, though. That language discharges obligations. That's not an extinguishment. And as we just learned in the Supreme Court decision in McGirt, treaties can only be extinguished by explicit language.
right. And the other thing is that this has not been changed by the Maine Constitution, so it is still in effect.
We just agreed it was still in effect. I want to get back to the issues at hand. I don't think that is helpful to move us forward. Representative.
In all respect, Mr. Chair, we're sitting here talking about providing the tribes with their inherent rights. Just like I sent the message to everyone out here, the fact that Mr. Taub and Representative Babbage are saying it in a manner that we're giving rights back to the tribes. We're not. These rights have never been taken from the tribes. They've just been prevented from using the rights that they have inherently. And in doing so, that was done without the assent of said Indians. Now, the Implementing Act, which in my opinion was a joke and poorly written, is now something that we've been working on for, well, I know Representative Harnett's been working on it for almost 2 years now. and has done a very good job, as well as you, Senator Carpenter, and others. The fact of the matter is that we need to go back and look at the original treaties as well as our own Constitution and apply that to now.
Okay. I don't know what to say. That provision of the Constitution is still effective. Representative Harnett, you want to?
Thank you, Mr. Chair. I just want to touch on the issue of putting something in Title 36 as opposed to amending the Implementing Act. And I'm happy to hear both Mr. Taub and Mr. Abello saying that the state is willing to amend the Implementing Act, because I think that that's critical. And I also recognize, as Mr. Taub conceded, he represents, the Office of the Attorney General represents the state. So representing the state, I would want things to be put in statute, because only the state has the authority or the ability to change those without consulting the other party. If I were representing the tribes, it's the exact opposite. I want it to be in the Implementing Act, because then both parties have to come together and decide whether or not to make a change. So it's a long way of getting back to Senator Bello's point. It is about, are we dealing with each other as sovereigns, or are we saying sometimes we'll deal as sovereigns, but on other issues we want it in statute so we can still control the game and change it with just one side coming to the table. So it's not really a question as much as a statement. And I think it depends on who you're representing. But then I would go back to everything that came out of the task force. And that was to put people on, the tribes in the state, on equal footing on these matters. And the only way to do that is by having things changed in the Implementing Act.
Thank you. Senator Bellows?
Yeah, I have a follow-up question on the tax piece, because LD 2094, when it was presented for public hearing, did have some significant taxation pieces as amendments to Title 30 in the Implementing Act. And so my question, because the Office of the Attorney General and the Office of the Governor are saying, well, these amendments that have been proposed most recently are so new, they haven't been fully vetted, we haven't been able to analyze them. And that is not, it is true, we always, in work sessions, we're always looking at new alternatives to language. But my question for the tribal attorneys, is this new language something that was, if you had your preferences, would the original taxation language around 2094 be your preference? What is the proposal that we see here today an effort to find common ground or compromise, given the proposal put forward by the governor and the conversations with the Office of the Attorney General? And I guess what I'm trying to figure out is this amendment language a poor compromise on what 2094 was? Because if we're hearing from the Office of the Governor that they're not ready to sign off on this language, I just want to make sure that we're not negotiating against ourselves.
So would.
Well, Senator Bellows, I would pause and let any of the tribal chiefs jump in here, but otherwise I'd be happy to provide a response to your question.
Thank you, Corey. Mr. Chair, and I appreciate the opportunity, and I'll be brief, but I just want to mention a couple of things in this conversation. I can't really get into the technical pieces of tax. It's not something that I gravitate to, but I know that these issues that we're talking about right now were the issues that were specifically asked of us to have a more detailed conversation on. And I would dare say, and the attorneys can articulate this, that this is our attempt to find some common ground here. It's not, I think in any negotiation or conversation, there has to be a little bit of heartburn on both sides. And I think that our attempt was to come to some common space in terms of the the purpose statement on there. That was the goal and objective and commitment of the process, was to get to the tribes to be in a more in a better place in terms of comparably to other tribes across the country, and to be able to elevate themselves in many areas. And so I don't think that's worth fighting about. I think it was really specific to these three issues in this bill was the intent there. So I guess I'm indifferent to what we do with that language. I think, but moreover, I mean, if we look at this entire process, the work group developed and talked about probably over 50 issues that affected the tribes negatively over the last 40 years. And I'll spare everybody and not go into all of that. But I think the other thing is, these 22 recommendations, the reason we got here today, and we've gotten here since 1980, is because we've been living for 40 years under a condition where we've been unable to have a meaningful voice in affecting change to address real conditions within the Indian Territory in Maine. Indians in Maine lag far behind everyone else in the country, and that is undisputable. And so when we talk about the approach and about fears of losing that unilateral authority, or fears over not being able to make that decision without the tribes, we're coming from two different perspectives here. One perspective is we want to retain that authority and be able to make those changes if it doesn't work for us. Things haven't worked for us for a very, very long time, and we've not had that ability. What we're saying is memorializing these changes in the Implementing Act allows for a sovereign to sovereign, government to government relationship. It doesn't give the tribe unilateral authority. It doesn't give the state unilateral authority. It gives us a process to follow that, yes, may be painful. It may not work for everybody all the time. But at the end of the day, that's the mechanism that forces us to have conversations and doesn't allow one party to say, I mean, we may make these changes and they may not work for us over certain circumstances moving forward. We're not going to be able to change those by ourselves. We're going to have to go and have a conversation about that. So we think with all these bills today that it's time to memorialize them, memorialize the work, get it out into the legislative process. And no one is saying that the conversation stops as this bill moves from the committee. We continue to have these conversations. There's opportunity in the process to continue to make changes. We're committed to that, committed to the conversation. But to me, and I'm speaking specifically for Penobscot, we cannot have a condition in this state where we're continuously legislated under state law when that goes totally against the autonomous sovereignty that we're trying to obtain for tribes in this state. And it continues to put us in a position where we're participating in a legal framework that doesn't tell the story of who we are and who we are as governments and what our responsibilities are to people. And so, so I personally respect everybody on this call, all your opinions. Everybody's worked really hard, and I want to acknowledge that. But without making changes to the Implementing Act, all we're saying is the state of Maine is not comfortable or does not trust that sovereign authority of the tribes right now, and they want some experiment to see if they can trust that. And at the end of the day, I don't think that's what the goal and objective was of this legislation.
Thank you, Chief Francis. Representative Babbage, you had your hand up.
Oh, yes, I'm on. Yeah, thanks. I wanted to thank Representative DeVoe for bringing up the Constitution. I was going to ask for his help, actually. A month ago, I tried to get that language that it has been unprinted since, I don't know, 1879 officially or something like that. But so if he could help me to get that language or whatever, I would very much appreciate it. You know, just in general terms, this discussion about what Chief Francis was talking about getting to a place, at least I think we're all hoping to get to. It is not sovereign to sovereign right now. The land claims case, if it was ever sovereign to sovereign, and it should have been according to the Constitution, as Representative DeVoe mentioned, that was taken away. I mean, I have to say that I think I shared this once before, that I was taken aback by the fact that the land claims case has been vilified in this process, when it changed remarkably things for the better for Maine's natives. If you want to take a look at 1985 versus 1955, see what the difference running water makes. The fact of the matter is that I remember Amzie Moore, a Southern black fellow from Alabama, I think he was, or whatever, in the Ice and the Prize series. Do you remember him? Remember that? He talked about the status quo being as terrible as it was in the 1950s in the South. But he said, you know, if that's the way it is, it must be the way God willed it. And people adapt. And then all of a sudden, Montgomery bus boycott happened, and Amzie Moore was lifted up, and it went from, I just don't want this for my children, I want this for me. I can see hope for tomorrow. The Indian Land Claims Act did something similar, I believe, and at least I've read testimony by some Maine natives who felt that we were invisible prior to 1979. And after 1979, and I will say, simultaneously, when the federal government started to wake up, but they really didn't wake up until after 2000. But the fact of the matter is, there was hope for the future, and things have changed dramatically for Maine Indians. The Penobscots and the Passamaquoddies financially are way better off than they were prior to that. Even Maine's treatment of the Indians in the past, which has been abhorrent, but in 1934, when the Indian Reorganization Act happened and John Collier changed a whole lot of things for the better, when they were thinking about taking over the case of the Maine Indians, they decided not to, because they didn't want to spend the money that Maine was spending, or at least had budgeted for the natives. I guess what I'm saying is the land claims thing awoke us all to the situation from Maine's natives. I mean, being from Southern Maine, a Passamaquoddy might as well have been a Zuni. I knew the geography, but I knew nothing about our native tribes. It wasn't taught in school. It wasn't anything like that. And I'm just saying that through our discussion today, I've come to appreciate what the downside is of the Land Claims Act. And that is this taking away of this sovereign ability that is inherent, I think, in our tribes. So that is real. Okay, so I'll just leave it at that. We are in a position of deciding whether it should be sovereign to sovereign. And I believe it should. I can't go there on gaming, because I know that if I give somebody freedom to go across the street and there's a couple of semis coming down the road, I'm not going to take that option. But as far as sovereign to sovereign, I think that's what we are trying to get to. It is not what is.
So Mr. Babbage, I just feel like
I was just going to say, I would agree with that in terms of that's not what it is right now. But I would just disagree that the Settlement Act provided a better tomorrow for Maine tribes. In 1976, and then previous, under the Indian Self-Determination Act approved by President Nixon, tribes started to access programs, whether that was housing, law enforcement, funding for social services, all of those things. The tribes were in that condition for 4 years where they were receiving federal funds, they were growing their tribal communities, and the Settlement Act provided, a lot of people think all this money got thrown at the tribes. that has helped with some land acquisition, obviously, but the Settlement Act didn't grant any rights to tribes, as we know. This whole effort was about restoring the rights that were taken away by the Indian Land Claim Settlement Act. And at the time, during those testimonies in 1980 and all of those things, and yes, we can compare it to 1968 when we couldn't vote in this state. We can compare it to the 1960s and 70s when there was no running water on the reservations. But the point is the tribes were climbing out of that during self-determination, and also were what this process has identified is the dozens and dozens of opportunities missed or blocked from tribes being able to access to truly grow ourselves. So we enjoyed a total sovereign status. We were under total federal jurisdiction, evidenced by murder cases and arson cases and other things that were the courts clearly determined to be under federal and tribal jurisdiction. And so I would just take issue, not with you, I have a great deal of respect for you, but I take issue with the fact that somehow the Settlement Act granted us the successes we have today. If it wasn't for the extremely bright, smart, and creative people within tribal communities today, we would be having a hard time keeping up to the level that we're at right now in terms of being decades behind everyone else. So I would just caution everybody that this thing is about a restoration of sovereign rights. It's not about what the Settlement Act granted us, but more so about what it took away. So I just wanted to mention that.
I
appreciate the opportunity.
I appreciate the clarification, and I understand. I was actually,
Representative
was,
Babbage,
yes,
could you defer, please? I really
okay.
would like to get the committee back on this bill, or I mean, it's 2:00 already. Senator Carpenter, is there something you needed to add?
Well, I just was going to, thank you, Madam Chair. That's exactly what I was going to say. I know that we've talked about artificial deadlines and all that. We're at 2:00 in the afternoon, folks, of the last day, of the last day, of the last day. And we can argue about the propriety or lack thereof of the Indian Settlement Act of 1980 all day long, and it's a great intellectual discussion to have. That doesn't move this piece of legislation or the other two that we're waiting on one bit. Thank you.
Thank you, Mr. Chair. So I think we were done with tax, and we just needed to do an overview of the criminal jurisdiction in this amendment. So Mr. Albright, is that your area or one of the other tribal attorneys?
I will defer to Ms. Binney on that, but I will take 10 seconds to answer Senator Bellows' question, which is that yes, the tribes believe that the tax provisions of LD 1392 are a good first step towards fulfilling the intent of LD 2094's tax provisions, and would be that we are very supportive of these provisions.
Thank you. Ms. Binney, if you could just give us an overview of the criminal jurisdiction in this amendment. Thank you.
I actually am going to defer to Kim Patwarden to talk about it, because a lot of what we've done here is that's in the amendment that you're looking at. About 99.5% of it is based off of the proposals that we last received from the state. There is, and I know Ms. Patwarden has probably caught it with her eagle eyes, there is one sentence that we removed regarding, crimes against the state, and only because we just want to work on the language on that and how to address that. But the reason why I'm deferring to her is on the Class C crimes. I don't want to misrepresent the intent of the state, and I think that the tribes are in a pretty good place with this language, but I want to, I think it's better for you guys to hear from the Attorney General's office about how we got there. So unless she defers back to me, I want to make sure she has an opportunity to talk through some of these issues. But I think we're in a pretty good place here.
All right, Ms. Patwarden, and you can't defer. Is she on?
I'm
She
here.
is on.
Oh, there she is.
I'm here. I appreciate the guidance on not deferring. So Ms. Binney's right. A lot of this language is part of the proposal, some draft language that that was circulated earlier in the week. I will put a caveat on that, in that this was draft language. It was not intended to be final language. And there are still, criminal attorneys in our office that are reviewing it and reviewing its various implications. So this is an idea, and it was concepts that we talked about, and this is putting that to paper, but certainly was not intended to be the final word on these topics. So I would say in broad strokes, what this amendment would do for the criminal jurisdiction of the Passamaquoddy, the Penobscot, and the Maliseet tribal courts is, one, it would put them all in the same position. That's not something that is existing under the current implementing act. So their criminal jurisdiction would be equal. That was one of the goals of the task force. So that would be in part what some of these amendments would do. Two, unlike 2094, this ties the criminal jurisdiction, the definitions of crimes, to state law. And instead of the tribe having exclusive jurisdiction over only Class D and E crimes, it expands that to Class C crimes. So there are more serious crimes that are now included within the jurisdiction of the tribal court. Class C crimes does not include any jurisdiction over Class A and B crimes. That would be arson, murder, significant assault, significant sexual assault, significant child abuse cases. So the jurisdiction would remain with the state regardless of the identity of the perpetrator. So there's the Class C crimes, and then it also expands the jurisdiction geographically, so that instead of the tribes having jurisdiction over only reservations for the Penobscots and the Passamaquoddies, it would expand that to all of the territory, so that the tribes would then be exercising criminal jurisdiction for crimes committed in those areas. You'll notice that in part, there's a second part, section 1A of the bill. This identifies concurrent jurisdiction in between the state and the tribes. This was a provision that was added in the VAWA bill that was passed earlier in the session, or I guess the previous session now. But it's expanded upon to also encompass Class C, D, and E crimes when the perpetrator is a member of a tribe, but the victim is not a member of any tribe. So the state would have concurrent jurisdiction in those circumstances. It also talks about the exclusive jurisdiction of the state, which would be for essentially everything else not stated. There's also a sort of catch-all in there that would permit the Attorney General's office to continue its work. There are certain statutory exclusive provisions that exist in Title V, where only the Attorney General's office has authority to prosecute or investigate certain conduct. Those would remain. And I believe it would also, I think the goal of this was that it would not affect the work of the Attorney General's office. And there was some language that we had talked about with respect to crimes against the state. It was, again, that would be to ensure that, certain acts committed, like, this would be tax crimes, perhaps healthcare, welfare fraud, those types of crimes where the ostensible victim is the state or one of its agencies, so that the state would retain jurisdiction over those prosecutions, where the state interest is stronger than perhaps the tribes would be in those particular instances. That's not part of what you have in front of you, but I understand from what Ms. Binney said that it was just really, they want to continue the conversation on that particular point.
Thank you. Questions or discussion from the committee on the criminal jurisdiction section of this proposed amendment? I'm not seeing any. So is there a motion? Representative Talbot Ross. Got to turn your mic on, please.
Thank you, Madam Chair. I would put a motion of ought to pass as amended on LD 1392.
Thank you. And is there a second? Seconded by Representative Evangelos. further discussion? Seeing none, I would ask the remote committee members to please make your way to the committee room so we can have the vote, as well as the committee clerk. Thank you. It's on that computer only, so. All right, so we are here. The pending motion is ought to pass as amended. Would the committee clerk please call the roll?
Representative Cardone. Representative Cardone is absent. Representative Harnett.
Yes.
Representative Harnett votes yes. Representative Evangelos.
Yes.
Representative Evangelos votes yes. Representative Curtis. Representative Curtis is absent. Representative Reckett. Representative Reckett is absent. Senator Bellows.
Yes.
Senator Bellows votes yes. Senator Carpenter.
Yes.
Senator Carpenter votes yes. Representative Bailey.
Yes.
Representative Bailey votes yes. Representative Babbage.
No.
Representative Babbage votes no. Representative Talbot Ross.
Yes.
Representative Talbot Ross votes yes. Representative DeVoe. Representative DeVoe is absent. Senator Keim. Senator Keim is absent. Representative Hagan. Representative Hagan is absent. 6 members voting in the affirmative, 1 in the negative.
Thank you. 6 members voting in the affirmative, 1 in the negative. The motion prevails. I'd remind committee members who are participating remotely that they have 24 hours to notify either the Speaker's office or the Senate President's office as may be applicable if they want their vote to be registered. So moving along.
No. Please allow me the opportunity to give my minority report.
All right.
Thank you very much.
I assumed it was not to pass.
It is
but-
not.
All right. So is it something that you can just let Peggy know?
I want to explain it on, we've been spent a great deal of time here, so I don't have it in front of me, but I can explain that it is ought to pass as amended. I am going to redesign the geographic description. I won't be using our current main governmental counties. I'll be using latitude and longitude, but it will be essentially the same. It will exclude the Kennebec watershed and Moosehead Lake area, but it will include the Penobscot watershed almost in its entirety, and I think it's well beyond what was actually considered tribal land at the time of statehood. So but in acreage, it's similar, very small change. I would like to also keep the criminal justice part and put that in the implementing act. And I would like to, I guess I would like to strike the tax section. I'd be willing to put that into statute. I don't know if that can be part of this, but not into the implementing act. So that's my minority report.
Thank you. And again, you can work with Peggy on your exact language. Thank you. And so we're now going to move on to amendment number 3, but we will give our remote members a chance to get back to their outside locations. So it looks like both Senator Bellows and Representative Babbage are back to their rooms. Senator Bellows, I think I'm going to turn to you. This is your amendment. I don't know if you want to highlight how this is different than the previous amendment you submitted that we've been working off from, or I would ask you who you think should be the person to walk us through this. I don't know who you've been working with. So Senator Bellows.
Thank you. And I would invite the tribal attorneys, perhaps Mr. Hinton, to start to walk us through. But just from a big picture perspective, I think that this is potentially historic, and I think it is really important work. I think we have an opportunity to rectify a historic wrong and to try to recognize Maine's tribes in the way that tribes in other states are recognized. And a lot has been said today, and I hope that all of us as committee members can continue to keep learning and try to go back and listen to what we have said and reflect on it, because I have some concerns that misconceptions, quite frankly, racism and white supremacy continue to persist in some of the things that we say and do and some of the conversations around this legislation. So this amendment is an amendment to an amendment. As you may recall, after 2094 was introduced with multiple hearings and then multiple work sessions after the extensive task force process that brought together multiple people, I brought forward this amendment that had been drafted in large part by the tribal attorneys, and then Sam Sumpt and Peggy Reinsch were helpful in bringing that into statutory language to try to reflect where we were at the time in these ongoing conversations. This amendment then became the basis for more conversations and work sessions that were then interrupted by the pandemic. But most recently, what I brought to you today is an attempt to excise the gaming language recognizing that there is emotion around gaming that sometimes comes from different places. I heard the Office of the Attorney General say this morning that they feel that has not sufficiently been done, and I certainly would be open to further minor technical amendment to achieve that. But the goal of 2094 is a comprehensive amendment to the Indian Land Claims Settlement Act to restore a historic wrong, and that is treating Maine tribes as a municipal subdivision subservient to the state rather than recognizing them as inherent sovereign authorities. And the devastating consequences of that are manifest in the data. And it's really important. We just had a Truth and Reconciliation Commission conclude its work a couple of years ago, looking at how Maine treated Native children in a way that other states did not, and wrongfully, horribly, horrifically, through recent memory, was taking Native American children from Native American families. And we recognize that as a wrong, but we need to recognize that some of this is embedded in the structures and systems that were set out, regardless of intention, by the Land Claims Settlement Act. So that's a big picture summary, and I would ask Mr. Hinton or any of the other tribal attorneys to walk us through some of the details. But I would encourage all of us to try to consider getting to yes on this, because each one of us could have written a different version ourselves. But part of this process is staying engaged in the way that the tribal attorneys and the chiefs have modeled for us, even when we're in areas of significant disagreement.
Thank you, Senator Bellows. Mr. Hinton, did you want to kind of highlight for us the changes? Again, we've had the amendment and we've been working on that for a long time. So I don't think you need to walk through the whole thing. I think most importantly, just what is different in this version from the most recent version we've been working off from would be helpful. Thank you.
Yes. Thank you very much, Chair Bailey and Senator Bellows. I'd be happy to walk through the highlights of what's in here. I guess at the outset, I would just say that there were a few issues, at a high level, there are several issues that have been addressed in here slightly differently than they were addressed in 2094. And before I start to scroll through the PDF I have up here on my screen, I'll just say that the land acquisition discussion that we just had, that land acquisition language, all of it has been inserted into 2094. And it's exactly as it was just seen by the committee in that other piece of legislation. We also, in the course of the tribal attorneys discussions with the Attorney General's office, when we started discussions in March to improve some parts of the bill where we all felt that there was some clarity that could be brought, we focused on a couple of different issues, in particular, one related to civil jurisdiction and the ability of the tribes to exercise civil jurisdiction in a manner equal to other tribes around the United States. And at a high level, there are a few places that we've addressed that issue here, and we can get to the specifics of that more in a minute. And then I'd also say there are a few places in here where that there is language that's been included to bolster the task force recommendation now in the legislation that the tribes ought to be able to benefit from so-called federal beneficial laws passed by Congress for the benefit of Native Americans. And there's a couple of places where we've attempted to bolster that principle. However, I will note very significantly, there is language at the end of the bill, which I'll point to, that makes clear in very specific language that despite the attempt of this legislation, which is one purpose of which is to bring the benefits of federal laws to tribes here in Maine, there is a carve out for the Indian Gaming Regulatory Act in two specific places. So that's the high level. And then I will just go through and highlight in broad brushstrokes the more specific places where we've effectuated those high level changes. On page 2 of this amended version of 2094, in the purpose section, you'll see paragraph 1 related to the rights, privileges, powers, duties, and immunities of the tribes. That has not been adjusted, but we did bolster that next paragraph to make clear that one of the purposes of this legislation is to make clear that the tribes will have the ability to exercise and benefit from laws and regulations that accord special status or rights to tribes and that those provisions or those parts of federal law should be applicable in Maine, notwithstanding parts of the Settlement Act that have to this point prevented those laws from coming into effect in Maine. That is, this language is, you're going to see language to this effect, specific references to section 6H and 16B of the Settlement Act. You'll see that popping up in a few places. Scrolling through, on page 3, you'll note that you'll see on 2A, the phrase Holton Band Trust Lands. Previously, it said Holton Bands Tribal Lands. The task force relied on the phrase tribal lands to, I think, more easily describe the territories over which tribes exercise jurisdiction under federal Indian law. In our discussions between the tribal attorneys and the AG's office, we realized that the definition or the term tribal lands doesn't appear in the Settlement Act, in the Federal Settlement Act. So we removed that language and reverted to the definitions of territory and trust lands that were previously in the Settlement Act, just to ensure consistency. So you'll see some of those changes throughout. There's something like 90 places where we were swapping out that language yesterday. You'll see a definition on page 3 of non-tribal citizen or non-member. This language, this definition is specifically intended to make clear and to help with an understanding and implementation of the civil jurisdiction provisions of this. And this definition, actually, it came out of the discussions that the tribal attorneys had with the Attorney General's office. There was questions raised as to when tribes would have authority over their own citizens, their own tribal citizens, or members of other federally recognized Indian tribes, or individuals that are not a member of a federally recognized Indian tribe. And this definition relates to that concern, and you'll see where it's implemented a little bit further on. You'll also see on page 5 the definition of tribal entity that Mr. Albright previously referenced. We've included that here again because there are references to the tribe's jurisdiction over tribal entities under this legislation. Scrolling through on pages 5 and 6, and for the next couple of pages, this is where the geographic land acquisition language was included. That language is the same as we just discussed. And that was approved by the committee. So I will just scroll through and beyond that. In section 6206, this part of the Maine Implementing Act was previously drastically revised by 2094 and by the amended version of 2094. But you'll see at the end that we added language here at the very end, similar to the very language that was up at the top, to make clear that the intention of this paragraph is to ensure that the tribes have the right to benefit from laws passed by Congress for the benefit of tribes, and have generally the right to exercise the rights, privileges, and immunities exercised by other tribes around the United States. And I guess it would be worth noting, this language is that I've now highlighted twice. It's this point about access to federal beneficial laws. It was already addressed in 2094 in some capacity, but in discussions between the Attorney General's office and the tribal attorneys, there was concern that perhaps the legislative and the state's intent around that needed to be more clear in the in anticipation of a potential legal challenge. So when you see this paragraph in a few places, we're referred to it as sort of a bootstrapping approach, where the state's intent to make sure that these federal beneficial laws do not conflict with the laws of the state, that is made clear in a few different places. So that's where that language comes from once again. Just continuing to scroll through, there are some changes throughout these pages referencing Indian territory and trust lands versus tribal lands. Again, there's a whole bunch of those swap outs that have been made. I'm just scrolling through here. Let's see. The criminal jurisdiction sections of this legislation do not reflect what was just approved by the committee. I just wanted to note that. The current provisions in here related to criminal jurisdiction are more specifically consistent with the task force recommendations. But I think that the tribal leadership would be perhaps open to assessing whether or not the language just approved might fit in here, but we have not included it in here at this point. Again, we're expecting that this is a continuing dialogue. At the end of page 23, you'll see a section, a new paragraph 5. And this paragraph 5 is intended to address the civil adjudicatory jurisdiction of the tribes over matters arising on their Indian lands. And it is just to make very clear here that the courts, the tribal courts themselves, have adjudicatory jurisdiction over, over actions arising on the territory in a manner consistent with federal law, and in a manner that should be implemented notwithstanding sections 6H and 16B of the Settlement Act at the federal level. And I didn't say it earlier, but those two provisions of the Settlement Act are those that prevent laws of general applicability, so-called federal beneficial laws passed by Congress for Indians from applying in Maine. So we've really called those out in a number of places because addressing that major issue was identified by the chiefs and by the task force as a priority many, many, many months ago. Just continuing to scroll through, you'll see that paragraph regarding the civil adjudicatory jurisdiction repeated in the sections for the Passamaquoddy tribe, the Penobscot Nation, and the Holton Band of Maliseet Indians. It is exactly, in those 3 sections, it's exactly the same, just with the names of the respective nations swapped out. Continuing to scroll through here, let's see, I believe the last major changes that I would highlight begin on page 35 in section 6215. The changes here, you'll see there's 4 new paragraphs that have been added. These 4 paragraphs are intended to more specifically define what the civil legislative authority, civil legislative and regulatory authority of the tribal nations would be. And these are, each of these paragraphs is intended to largely capture the rules of federal Indian law. The tribal attorneys and the Attorney General's office, as we talked through these issues going back many months, had questions as to whether or not the way the 2094 was drafted was entirely consistent with the rules of federal Indian law. And so these sections here, paragraphs 1 through 4 on page 36, are specifically intended to ensure that the tribes can exercise civil, legislative, and regulatory authority in a manner consistent with tribes elsewhere in Indian country. And generally, that means that the tribes, the laws of the state, and I'm just going to quickly paraphrase each of these paragraphs. Paragraph 1, the laws of the state would apply to non-members of the tribe in the territories, in their territories, to the extent provided in federal Indian law. So the state's residual jurisdiction over non-members would be preserved. In paragraph 2, this is to make clear that the tribes themselves and their members would not be subject to the laws of the state and municipalities when acting in their respective territories and Indian lands. In paragraph 3, this is to provide that the tribal nations would have exclusive regulatory jurisdiction over tribal members and their entities when acting within tribal territories, notwithstanding the provisions of the Settlement Act that would prevent federal beneficial laws from applying. And finally, paragraph 4 would provide that the tribal nations and the state and local governments would have concurrent civil regulatory jurisdiction over non-tribal citizens. So this is to really make sure that the state is not, and the municipalities would not be completely relinquishing their authority to regulate any activities on Indian lands. That jurisdiction would be concurrent with respect to non-Indians. Finally, in paragraph, in section 16, this section specifically deals with the application of federal beneficial laws, and this really ties to that purpose section, those statements of purpose at the top of the legislation. And you'll see here very, very clearly, these sections provide that with the explicit exception of the Indian Gaming Regulatory Act, the tribes would have the ability to benefit from laws passed by Congress that are passed for the general benefit of tribal nations, notwithstanding the relevant sections of the Settlement Act. And so you will see that there are 2 places, both with respect to laws passed prior to 1980 and both with respect to laws passed after 1980. Before and after, IGRA has been explicitly carved out. So just to touch on the concern raised briefly by Mr. Taub earlier, that IGRA has not been carved out. I think everyone can see on pages 36 and 37 that it is very clearly carved out. The purpose language that is at the top of this legislation that references the purpose of according the tribes in Maine rights similar to those elsewhere in the United States, that declaration of purpose would effectively be with the caveat that the tribes would not have the right to engage in gaming under the Federal Indian Gaming Regulatory Act. So that is a high level of the changes that we have here, and I'll stop. And I think that myself and my colleagues are happy to answer any questions. Thank you.
Thank you, Mr. Hinton. So Peggy, I just have a question. And given the language in here, accepting out the Indian Gaming Regulatory Act, if we pass both 2118 and this as it sits, does that create a conflict?
Yeah, I think there might be a better way to accommodate in this bill the idea that 2118 could pass. Maybe we add a new subsection 3 that says something about IGRA, notwithstanding 1 and 2, IGRA may apply only as specifically provided. 2118 amends the implementing act to allow the tribes to engage in gaming under IGRA. So I think I think we should word it a little bit differently than the way it's presented here. The way it's presented here is a standalone bill. We're not going to cover IGRA, and I just think it might be better to word it differently to provide for IGRA to be incorporated into Maine laws in a different bill. So I think we can do it. I just don't think we do it exactly this way.
All right, thank you. So Mr. Taub, it looks like you wanted to go over in particular the new sections. I know the Attorney General's office has commented on this amendment in the past, the original bill, this amendment, but certainly I think the committee would love to hear your thoughts, or the Attorney General's office thoughts on again the proposed new sections. Thank you.
Yeah, so we really have not had a chance to look at this one at all. We've been focused on the other two, and so we've only been able to give this most recent amendment just a really cursory read. But having said that, I really do not understand Mr. Hinton's point about carving out IGRA and why that would mean that the tribes would not be able to conduct gaming. I mean, just to be clear, the First Circuit has already held that IGRA does not apply in Maine. The reason that the tribes currently can't conduct gaming operations is not because IGRA doesn't apply, but because state law does apply to them. So currently they are subject to state law, including the state's gaming laws. So because under this act, and there's a whole bunch of different provisions at play here, and that's why it's really hard for us to kind of go over this, because there's a bunch of interplay between the different provisions in here. But for example, one thing that this bill does is it strikes the provision in the current act that says that the tribes are subject to state law. And then another thing that it does, and I'm sorry I'm kind of being disjointed, but it's just because I haven't had a chance to really look at this or make any notes. But another thing that it does, and I wrote my notes, this is on page 35 and 36. So let me just get there. Yeah, so on the end of page 35, so this is section 22, application of tribal law and laws of the state. It carves out again the application of state law to certain activities occurring on tribal lands. And then sort of the final piece is that even though there's one provision in the act that does carve out IGRA, there's some other provisions in here that talk about the application of federal law that don't carve out IGRA. So, I mean, I can tell you with, I think, pretty good certainty that this bill, if it passed, would permit the tribes to conduct gaming. The fact that IGRA is carved out is irrelevant. Now, again, that's a policy call for the legislature, But unless I'm missing something, and I certainly, again, I read this quickly and I haven't fully digested all of it. And so I certainly would stand to be corrected by any of the tribal attorneys, but I just really don't understand how this bill carves out gaming. You know, there's some other issues. I think a lot of the issues we've discussed in our testimony. I think one thing that might be a little bit different in this bill, and I don't know if this is a change that's been discussed in the committee before, is with respect to the regulation of fishing and hunting. And so one of the things that I'm looking at page 15, section 2A, which says solely for conservation purposes, the state has jurisdiction with respect to the regulation of fishing, hunting, trapping, and other taking of wildlife by Indians off Indian territory or trust land to the extent permitted under federal Indian law. So one thing that we've just sort of been confused about all along is that it's our understanding that nothing in this act is intended to confer hunting and fishing rights to tribal members off of their land, so off of the reservation or off of their territory. So if that's the case, then we don't understand why there's this limitation on the state's ability to regulate tribal members when they're fishing and trapping and hunting off of their lands. So we're just not, that just really is something that we haven't been able to sort out. And this kind of all relates to this issue of treaty rights, which was at the beginning. And I know that there's a disagreement here. I know that the tribes disagree with the state on this point, but the Attorney General's position is that the 1980 Settlement Act did not codify or incorporate treaty provisions. That after the 1980 Settlement Act, it's federal and state law that defines the relationship between the tribes and the state, and you don't look anymore to the treaties. And so to the extent that this law tries to sort of reincorporate the treaties, it can cause a bunch of different problems, but one of the ones that I think I can most concretely flag for everyone is this issue about sustenance fishing. So the tribes already have certain sustenance fishing rights. This is going to expand their sustenance fishing. And so now I think I'm still looking, well, I'm not sure where I am at this point. Yes, I think I'm on page 16. So section 4, sustenance fishing and taking of wildlife within Indian territory or trust lands. So what this does is it expands sustenance fishing. Well, so first of all, it expands it not just to fishing, but also to wildlife. And it expands it to the Holton Band as well as to the Passamaquoddy and the Penobscot. And it expands it to not just the reservation, but to their territory. And I know you might think, well, sort of what's the big deal about expanding the sustenance fishing and hunting rights? But the thing that I want to sort of flag, and this kind of relates back to the issue about the treaties, is that there's an argument that tribes in other parts of the country have been successfully making, including one case that went up to the US Supreme Court, where tribes have argued that the right to sustenance fish doesn't include just the right to take, as many fish as are necessary for a person's sustenance, but it also requires the state to ensure that there is a certain quantity and quality of fish or other wildlife for the tribes to exercise their sustenance fishing right. So it's not just enough for the state to say, you can catch whatever fish you can find. The argument is that states have a treaty obligation to also ensure that there is a sufficient quantity and quality of fish or other wildlife. And so in the case that went up to the Supreme Court, which is sort of the most recent example, that was a case where the state of Washington was involved, and the argument was that in order to ensure that there was sufficient fish available for sustenance fishing, the state had to modify or replace a bunch of culverts, and so according to the state's estimate, it was going to cost them about $2 billion to upgrade all of their culverts to apply for fish passage. So something that we've suggested to the tribes during our negotiations is that to avoid that kind of situation here, we were hoping to have language that would be incorporated into this statute that would make clear that the sustenance fishing right or sustenance hunting or sustenance trapping right doesn't include any kind of right to a sufficient quantity or quality of the animals, that it's just the right to sort of, catch for your individual sustenance, but doesn't impose an affirmative obligation on the state to ensure any specific quantity or quality. And so that's something that we weren't able to reach an agreement on. I think, it would be much more, we'd have a lot more certainty if we could have a provision like that in. Again, I think if you just sort of look at it superficially, you think a sustenance fishing right, that doesn't really seem like a big deal. But, for the state of Washington, that ended up being a price tag of perhaps $2 billion. So our recommendation, and I think this is something that we've told some of the subcommittees in our testimony, is that we really would strongly recommend that there be some sort of, again, to use the term guardrails, some sort of guardrails put on what the limits of that sustenance fishing right are going to be. So let me pause there, except I do just want to again say that really, I've literally spent about 20 minutes looking at this, and I haven't been able to compare it to some of the other versions that have been out there. I also will ask Kim, who may have had a chance to look at things a little bit more closely than I have. Just Kim, is there anything big that I missed that you wanted to comment on?
No, I will note that I know that Corey said earlier that the criminal provisions are not the same as what was just passed in 1392, but that's also the same for the tax provisions as well. So there would be an inconsistency between those two particular bills and the scope of what's going on there.
Thank you both. Representative Evangelos, you had your hand up.
Thank you, Madam Chair. Yes, just a question for Attorney Corey Hinton, please. On page 36 of the amendment, the section of the law 6215, paragraph 2. And I read the Supreme Court decision in July affecting Oklahoma. Wasn't the findings by the Supreme Court, didn't it verify the very language you're using here?
Thank you very much, Representative Evangelos. The Supreme Court decision, are you referring to the McGirt decision?
Yeah, it was
regarding
the one in reference to Eastern Oklahoma.
Yes, yes. So the language that we have here, that case deals very squarely with the existence of the Muskogee Reservation as established by treaty. This language that we have here on page 35 and 36 doesn't go to precisely go to the continued existence of the treaties, but I think it goes without saying that there's a difference of opinion between the Attorney General's office and the tribes with respect to the continued existence of those treaties. I thought I heard earlier from Mr. Taub that the treaties are still in existence. And then I heard from Kim that the obligations to uphold those have been discharged. So there seems to be even perhaps some room for disagreement within the Attorney General's office regarding this point. I would just say with respect to rules on fishing, for example, and the import of Supreme Court decisions regarding the need to ensure the unobstructed passage of fish, at least from where I come from, at the Passamaquoddy tribe, we are actually out there removing these culverts and dealing with these things. And we do this pursuant to our continued proclaimed treaty rights. And those treaties, which are part of National Archives, very clearly lay out the boundaries of the Passamaquoddy tribe's territory. They very clearly lay out the areas where the tribes would expect to be able to engage in fishing activities. And those areas are all very closely clustered around where the tribes where the Passamaquoddy people have lived since time immemorial. So it is fundamental to how we're approaching 2094 that the rules embedded within the McGirt decision, the principle that treaties are the law of the land and cannot be extinguished except by explicit language. That principle is very much inherent in our approach to this. And I believe, and I don't want to speak for the other tribes, but I feel that although there are lessons from the McGirt decision with respect to treaties that are certainly Perhaps relevant to this issue at the 2094, that Supreme Court decision should have no literal bearing on 2094, but the tribes would maintain that those treaty rights that are specifically upheld in the Maine Constitution and that have never been extinguished by the state of Maine still exist.
Thank you.
Thank you, Mr. Hinton. And this question may be for you or the other tribal attorneys. Was it the intention in 2094 to incorporate the language from 1392 in regards to criminal jurisdiction and taxation? Were you looking to mirror that language in 2094?
That's a great question. And I think that the way that 2094, as we have it in front of us, lays out, it was not the intention to copy and paste that language into here. I think that, and I don't want to speak for the chiefs, and I would defer to them on our legislative strategy here, but the tribes have put forward 3 bills here in the hopes that 2094 or the level 1 bill that we just went through, 1392, might be enacted. It's our hope that as these bills proceed, that we'll have an opportunity to reconcile them to the extent needed, to the extent that makes sense. But when we were doing this work last night, it just wasn't clear exactly what the path forward would be. But we did know that if there was going to be a special legislative session, that we'd be working very closely with the Attorney General's office and the Governor's office to reconcile the language. And I believe that the chiefs and the tribal attorneys are here prepared to do that work if needed.
Yeah, and if I may, Chair Bailey.
Go ahead.
Thank you. Yeah, just responding to that with respect to the tax piece. As I indicated earlier, none of the provisions on tax in 1392, in our view, are inconsistent with the tax provisions in LD 2094. But what they do is they flesh out, they bulk out, put a little bit more meat on the bones of the very high level concepts that you see articulated in LD 2094. With respect to the particular issues that the Governor's office indicated they were willing to discuss, which is the sales tax piece and income tax piece, and then dealing with the concurrent jurisdiction piece. So I think that as we move forward, some of those provisions that have been drafted for 1392, could be brought over into LD 2094 to help flesh out the more general provisions on tax there. But we don't see there being any inconsistency.
So I would say
I would add, though, on the criminal jurisdiction pieces, we would need to do an amendment to add in the criminal jurisdiction so they mirror the same. I think the goal in getting 2094 out of the committee is to just be able to show some movement, given all the commitment over the last 16 to 20 months that have gone into drafting and the work sessions and the task force meetings to pick 2094. It's really more for the next legislative session to have a place to start with, so we're not starting from scratch. I think that the hope is that 2118 and 1392, in particular 1392, is the bill that would actually be taken up in special session and given some floor time, and that would be the bill that we would want to focus on in continuing dialogue with the Attorney General's office and the Governor's office. But I think from LD 2094 standpoint, I think it's just important to show the constituents of the tribal nations that this committee's work over the last year and a half is resulting in something moving forward out of committee.
Thank you. For what it's worth, I would like to see at least the criminal jurisdiction part from 1392 be incorporated into 2094. I just think that language is clearer and more encompassing. I like how it's set up with just, C, Ds, and Es instead of getting into this penalty and the $5,000, which just, it makes my head spin. So, but it wouldn't be something that would make me vote or not vote for 2094, but Senator Bellows, just something for you to consider when it comes time to make a motion. Further discussion, questions? Seeing none, do I have a motion? Senator Bellows?
Yeah, so, and I encourage the tribal attorneys to interrupt me if I get this wrong, but I would move ought to pass LD 2094 as presented and further amended to reflect the criminal, substitute the criminal jurisdiction provisions that we just went over in 1392. So there's congruence between those two pieces, on that piece between those two bills.
And would it also, Senator Bellows, be your intention to have Peggy and Sam work on language that Peggy indicated, maybe adding a paragraph 3 at the end, just to make it clear that the intention is to accept out gaming in this particular bill?
Yes.
All right. So there's been a motion. Do I see a second? Seconded by Representative Talbot Ross. Further discussion? Representative Harnett.
Thank you, Madam Chair. Just want to make a few remarks. I want to start off by thanking everybody who's in this meeting today and for everybody who's worked so hard over the last almost 2 years on moving these bills forward. And I want to start with some personal comments. We have taken your ancestral land. We have taken your children. We have polluted your water so much that we warn you not to eat fish from your rivers, the rivers that provided you sustenance for millennia. We have treated you as less worthy, less important, less valued, as less than people, and we memorialize that treatment in our laws, our regulations, and our systems. We have treated you as wards of the state and not as free human beings with the liberties others enjoyed. We have turned a blind eye to the physical and sexual violence that resulted in death and disappearance for some, and a lifetime of trauma for so many more. We have tried to strip you of your culture, of your language, of the traditions that defined you, because we thought you should be more like us. And we have broken and dishonored treaties and promises made over and over again. How dare we? And for that, I am sorry. We have formed commissions, study groups, work groups, Truth and Reconciliation Commission, task forces, and more. But what has really changed? Where are we today? We're looking at LD 2094, which represents 16 months of work by many interested parties that resulted in 22 consensus recommendations. Those 22, those with recorded votes, 19 were unanimous. 2 had 1 dissenting vote. Essentially, there was near unanimity on every recommendation brought forth by the task force. Yet after all of that work, all of that collaboration and discussion, all of the public hearings and public work sessions, all of the work done by the tribal attorneys, the Office of the Attorney General, and to some extent, the Office of the Governor, other than LD 2094, today we were left with only 2 watered down versions of 2, maybe 3 out of those 22 recommendations. And after all that time and all that work, Maine does still not seem ready or prepared to recognize the inherent sovereignty of Maine's First Peoples or to act on the remaining 20 recommendations of the task force. This is not the type of progress I was hoping for. In my mind, it is another insult to the tribes and diminishes the efforts of the members of the task force and to everybody else who has worked so hard on this. I don't want this to be the end. If Maine refuses to recognize the inherent sovereignty of the tribes, we're not giving anything back, nothing of substance will ever change. Sovereignty has to be the starting point. Sovereignty is not part of the negotiations. That is why I support LD 2094 as amended, because it can address historical wrongs and hopefully pave a path to a better future. Thank you.
Thank you, Representative Harnett. Representative DeVoe?
Thank you, Mr. Chair. I'd like to thank Tom for all of his hard work that he's done on this, and all the others that have really put some time and effort into this. And I'd like to have everyone take a minute and go back to a joint resolution that was signed back in the 126th, and it's the joint resolution acknowledging the Treaty of Waterton of 1776 on the occasion of the President George Washington's birthday. And in it, it discusses, and I'll read this portion, and it is also recognized as our nation's first foreign treaty concluded by the United States of America. We need to honor the treaties that we or our ancestors have signed. This is a great first start if this gets through, and if it does, and I hope that those of you that return next year will continue this and make sure that this actually goes through. I'd like to thank each and every one of you.
Thank you, Representative DeVoe. Other comments, members of the committee? Representative Talbot Ross.
Thank you, Mr. Chair, and I want to thank my colleagues for expressing what so many of us are thinking. Just want to say that it is my hope that while we have not reached agreement on these bills, that the affirmative votes that were taken today will serve to memorialize the efforts by the tribes and many in the state to make progress. And so we have a whole lot more work to do. I know that there's commitment by many in this body to do the right thing. And I just hope that we get something over the line, that we can get something passed so that we can continue to move these discussions a little bit further. I know today was pretty painful, to be honest, right? Some of the discussion, I think, took me back to when I was a child, thinking, having my father work on these exact same issues and bills as a member of this body, and just feeling really disappointed today. I joined my colleagues in feeling this way, but very disappointed that even the level of engagement hasn't really improved. And so I've been sitting here, holding my tongue, I would say, for most of the day because of pure outrage, really. And what I'm feeling must pale into comparison for what tribal members and leaders, attorneys have been working on for far too long. But I take my vote today in honor of that work and know that this is just a moment in time to memorialize some progress that was made with the very, very hard labor, I would say disproportionately, on the very people that we should have never asked to come to the table if we weren't serious about recognizing their inherent humanity and sovereignty. So I take this vote not proud that these bills reflect the best, but as a way to memorialize that we need to do more. And progress will come. I believe that it will. I believe that it will. Thank you.
Thank you, Representative Talbot Ross. Representative, excuse me, Evangelos.
Thank you, Mr. Chair. I just wanted to thank all the parties who contributed to this effort. It was an honor to work with all of the tribal chiefs and members of your community. And Representative Harnett's words were very strong. I won't repeat them, but I will say that if I am reelected and we need to take more of this fight up next year, I stand ready. Thank you very much.
Representative Babbage.
Thank you, Mr. Chairman. Obviously, this has been a difficult day for me. I've accepted the role of devil's advocate in some cases. I hope nobody has misconstrued what I'm doing in this process. I am sure by how I vote today, if the tribes went home with what I approve, they would see a tremendous advance over the status quo. But I am still going to try to craft good law as I see it. I apologize to really the effort of the tribes overall for having made this 2-year effort, talking to basically a small group of the legislature, which is only one branch of government. And I have negotiated before, painfully, with people who at the end could not deliver, but had to answer to somebody else. And but that does not diminish, I don't think, the work that we do here today. I have concerns. The sovereignty to sovereignty, government to government relationship it is something that I think is right. I would prefer to put it in state law to make sure that I don't make such a mistake that it will be regretted. But I had 2 things here today that I could not approve as good law. One was had to do with land acquisition and gaming as a result of that. And the second has to do with something that's very dear to the tribes, but something that I have a problem with, and that's sovereignty that is undesignated. In other words, I have a hard time arriving at sovereignty or recognizing sovereignty as it may on land as it may exist at some point in the future. I don't see that as responsible on the part of so as far as I'm concerned, yes, I have a designation for the lands that I thought the tribes would be very, very appreciative of, because it's way larger than what they were recognized as having upon statehood. But it's similar to what they've actually come up with themselves. I think they stole my thunder a little bit. But the second part is that lost my train of thought. But the idea that we can give, whether it be, and I think I've mentioned this before, whether it be a foreign power or our native tribes or the state of New Hampshire, the power to make a determination on a piece of land in our own current area that we don't know, that is as yet undesignated. I do have a problem with that. What I am in favor of is not granting, I guess you don't want to say it that way, but it is a surrender of recognition of power by the state of Maine over lands that are in the hands of the tribe within the designated area that we've talked about as of January 1st, 2020. That's huge, but it's not enough according to the rest of the committee, and I'm sorry for that. But so I will be voting ought to pass as amended, but it will have those 2 caveats. So, thank you.
I don't want to belabor the discussion here. We've had a long day and we need to get to a vote. I do want to say, however, this has been a long process for myself. Representative Bailey and I began the discussion about this very shortly after we were sworn in January, almost 2 years ago now. And our leadership agreed that it was an important issue, and we've gone forward from there. I'm not sure as we sit here today that this will result in a tangible change because of circumstances beyond our control. I hope it does. But I also hope fervently that the discussions and the negotiations and the goodwill, if you will, that has, I think, begun here between the state and the tribes continues. Excuse me. I appreciate all the hard work that the tribal attorneys, tribal representatives, the chiefs, the state, the Attorney General's office, and the governor's office have put into this, and my fellow committee members. I would like to be more eloquent, but what I would say beyond that would pale compared to what Representative Harnett has said. So I would echo what he has said and move on. I'm looking for a motion. Do we have a motion?
I made
We
it.
have a motion. I had a motion on the floor.
Chief Francis would like to say something.
Who are we? Oh, I'm sorry, Chief. I didn't see you here. Okay.
Oh,
Chief.
that's okay. I just real quickly, I know we're getting a little fatigued here, but I just wanted to say on behalf of Penobscot Nation how much I've appreciated the conversation over the last 16, 17 months against a ton of skepticism on my behalf and of course, members of our nation as well about kind of where things were, where they would go, and if they would actually get to where we wanted to. Now, I don't know where this is going. The real work starts now. But I know that I'm appreciative of everyone on the call. I've heard a lot of comments today about apologies and heartfelt condolences to the tribes. And I just want to be really clear that none of the individuals on this call bear that cross. I mean, you're not personally responsible for how we got here or the historical tragedies that have taken place with Maine's tribes. You have all have our respect, and it's my hope that that this conversation turns into real change for real people in a real condition, which is all this was really ever about. So the tribes of Maine are not interested, in being perpetual victims. The governments we have are strong. We're working on behalf of our people. We're providing and contributing to this state and our regions. And I'm reminded of several of those efforts today as this call was going on. But again, I appreciate everybody's comments, and my hope is this conversation continues through the legislative process. We get real and meaningful change that we can hang a poster of success for, and which builds trust and processes for going forward. So I'm appreciative of you all, and thank you for initiating the process, for inviting us to the process, and hopefully we've changed some hearts and minds here. So thank you.
Thank you, Chief. Others who would like to weigh in, and I apologize, I didn't see you trying to get my attention. All right, pending, we need to get the folks who are in the building, but not here. So if they would make their way this direction.
Shoot.
A reminder to the folks who are the committee members who are participating remotely one more time. You have 24 hours to record your vote by calling the Speaker or the Senate President. Thank you. Any of the committee members that have expense vouchers, get them to myself or Representative Bailey, please. I'm gonna keep mine because I've
Okay.
got to get a receipt from the hotel
All righty.
and I'll get it in tomorrow.
Sounds like a plan. Thank you so much.
Thank you. All right, pending motion before the committee. It's my granddaughter. Pending motion before the committee is the motion ought to pass as amended. No further discussion. Ask the clerk to call the roll, please.
Representative Cardone. Representative Cardone is absent. Representative Harnett.
Yes.
Representative Harnett votes yes. Representative Evangelos.
Yes.
Representative Evangelos votes yes. Representative Curtis. Representative Curtis is absent. Representative Reckett. Representative Reckett is absent. Senator Bellows.
Yes.
Senator Bellows votes yes. Senator Carpenter.
Yes.
Senator Carpenter votes yes. Representative Bailey.
Yes.
Representative Bailey votes yes. Representative Babbage.
No.
Representative Babbage votes no. Representative Talbot Ross.
Yes.
Representative Talbot Ross votes yes. Representative DeVoe.
Voted yes.
Representative DeVoe is absent. Senator Keim. Senator Keim is absent. Representative Hagan. Representative Hagan is absent. 6 members voting yes, 1 voting
6
no.
members voting the affirmative and 1 member in the negative. The motion ought to pass as amended prevails. My understanding that Representative Babbage will be preparing a minority report.
Yes, Mr. Chairman, I vote yes on LD 2094 with a minority report to change the geographic identification and to put the date at January 1st, 2020.
Okay, so you will have an ought to pass as amended minority report at this point of 1, but there may be others who wish to join you. The other committee members remotely can either can record their vote through their presiding officers. Thank you. Anything further other than introducing my granddaughter who just snuck in the back of the room? If no, yeah, Senator Bellows.
Because it looks like this will be the last Judiciary Committee, I just wanted to say I appreciated Representative DeVoe's participation, and although he and I were on opposite sides of the aisle and didn't always agree, I particularly appreciated his passionate advocacy on issues affecting Maine's Wabanaki tribes. So thank you, Representative DeVoe.
Thank you.
Other.
Mr. Chair, may I clarify? I said the geographic area would be January 2020, but I did want to include that sovereignty would be recognized as of that date to Indian country as of that date, but that I support the full 150,000 acres per tribe and 5,000 each for the Maliseet and Micmacs as provided by the land claims.
Thank you, Representative Babbage. If there's nothing else come before the committee, I believe that concludes our business for the day. Thank you all.